May I permit to mention, my lord, item number 16 of my lord's list, my lord, I will be seeking for accommodation. I am for the opposite party, my lord.
Let 16 comes.
My lord, my juniors will be.
Yes.
My lord, it's the second death, my lord.
Have you served?
I have served the notice.
On matter of hearing, my lord. With notice, my lord, I am on matter for hearing, my lord.
Have you served?
I have notice is there. I have given notice, my lord. Okay, okay. Yes.
My lord, got the application.
Who are you? Who are you?
I am personal, I am active person, dispose of case,
Accused.
active case dispose of, right? Case dispose of.
Where is your lawyer?
No, I am person.
You are appearing in person.
Yes,
What do you want?
that's right.
What do you want? Let me understand.
Recalling the application, share,
Recalling the application.
trial application.
এটা কাকে সার্ভিস করেছে? Office of the Public Prosecutor. And what about the others? Who are the opposite parties apart from state?
State government.
And who else?
Huh?
And who else? আর কে আছেন স্টেট ছাড়া?
States are also.
আপনি লিখেছেন তো and others.
Active person is other.
শিশির কুমার সাহা.
Another. And the.
Who is শিশির কুমার সাহা?
Yes, I am the Supreme Court.
You are শিশির কুমার সাহা. State of West Bengal and others you have written. Who are those others?
Others, that is typical mistake.
Correct it. Either you serve upon the others or correct it.
Sir, it responded. Bharti responded. State responded. Another. No, responded. Only responded.
I ফেরত দিন তো কাগজটা।
अच्छा राधा
এই তো আগার্স লিখেছে।
हाँ हाँ
Yes.
Mr. Bose.
দেখি ওটা কি ছিল।
Well, at last occasion, I had relied upon my lord 2 judgments, but unfortunately, my lord, we could not hand it over at the time when we were relying upon those judgments. My lord, these are the 2 judgments. I start with those 2 judgments first. And I just hand it over to your lordship. You know. One was 2021 SCC Online Supreme Court 147.
Just give me.
And the other one was AIR 1990 Bombay 170. I had
Come again, please, Mr. Basu.
My lord, on the last 2 judgments I had already relied upon. One was 2021 SCC Online Supreme Court 147. Your lordship had already taken note of that.
I have taken note of it.
Yes, yes. But we did not hand it over to your lordship.
Okay.
I had relied upon from my iPad. And the other one was, my lord, AIR 1990 Bombay 170. My lord, both these judgments were on the point that if the statute requires something to be done in a certain manner, And if it has not been done, it's void.
Yes,
This is based on that, my lord, the provision of the Tenancy Act, where prior permission before transfer was mandatory.
yes,
So that is why, my lord, since admittedly the present plaintiff had obtained the transfer from the previous legal heirs without
Without-
prior permission
yes,
from the
that
Thika
is what
controller.
you
My
adverted on
my-
the other day.
Lord, may I just hand over these
Yes,
two
yes.
judgments? So that was my first point. Then the suit could
Hmm.
not have been proceeded with or decreed so far as this ground is concerned.
Hmm.
This completely non-suits the plaintiff. So now your lordship will kindly come to what was their ground for eviction.
Hmm.
Well, there were two grounds. Well, there were two grounds, admittedly: default and addition on alteration.
Hmm.
MOP section 108 of the transfer of property.
Yes,
So, my lord, so far as default is concerned, my lord, it has been held by the trial court and the appellate court, but there has been no default. So default ground is against them. Before both the courts, default ground has been held against them. Now, my lord, if your lordship will kindly take the second ground.
Hmm.
My lord, the second ground is addition and alteration.
Hmm.
My lord, kindly first, I'll just wish to draw your lordship attention to the relevant portion of the plaint. What is their case? Lord, kindly have a look at the plaint first.
hey, LCR to put into.
Just one paragraph from the plaint. Lord, kindly take the trouble of coming to paragraph 5.
Just wait for a while.
সে আলাদা কথা সেপারেট কপি দেবে না বারবার তুই দেওয়ার পর দেখো প্রিন্ট দেখবে এই তো I'll just try and give your lordship a separate copy of the plate.
Paragraph
Para 5. খুঁজে পেয়ে গেছি।
5. Yes. Para 5 ABC.
My lord, kindly take grounds for eviction.
Hmm.
A. The defendant has illegally and unauthorizedly made addition and alteration in the said coal shop room in the suit and has also constructed CI roof under the RT roof
Hmm.
without the consent and permission of the landlord, previously obtained in writing as required under the law. The shop room has been illegally partitioned into two parts,
Hmm.
and in one part thereof the defendant is running a Modi shop business without the consent and permission of the landlord. So, my lord, this paragraph, if your lordship will kindly consider, has got several allegations. My lord, his first allegation is the omnibus allegation. I have made addition or alteration. Very good. Now let us examine what addition or alteration is he complaining of. Because, my lord, as I understand, subject to, my lord, correction by your lordship, that it is the plaintiff who has to prove his case. It is not based on the defendant's weakness.
Absolutely not.
So what is the plaintiff's case?
Hmm.
And, my lord, by the help of an advocate commissioner, you cannot improve your case. You prove your case. A, you give evidence, unimpeachable evidence, then advocate commissioner, engineer commissioner or advocate commissioner aids That's a support to the court. He's an officer of court, it's a support to the court. So now let us examine what case he has made out. Now, my lord, first allegation is constructed a CI roof under the RT roof. What would that mean? CI roof under the RT roof. So, my lord, this is the allegation. So now we have to see in evidence what does he mean by CI roof, and constructed a CI roof under the RT. So basically the roof is a RT roof. RT roof would be so well, kindly see, there is RT roof is RT roof, there is no explanation. So we'll examine what RT roof, by RT roof, what did the plaintiff mean? And under the RT roof, a CI roof. Very well. Whether that is possible to be constructed or not, I am not aware of this. Now, without the consent and permission of the landlord. So he says that he has to first prove that I have constructed the CI under the RT. Then he says the shop room has been illegally partitioned into two parts. So one part I am using as Modi shop. Very good. Without the consent and permission. So he says, if your lordship will see the Modi shop part, that I am carrying on business without the consent. So he says that if I carry on Modi shop business, I need his permission. So even if I assume that allegation to be correct, that doesn't come under addition and alteration at all. At least the partition does. Now let us see what partition is he talking about. Now, my lord, kindly take here. Once, my lord, kindly take paragraph C once. The next page.
Yes.
That without the consent and permission of the plaintiffs and or the then plaintiff, the defendant has constructed in the inside of the disputed room by a partition wall. My lordship will kindly make a note. Wall. It's a wall. So it has to be a civil structure. And also a concrete left. Very well, we'll read it as loft. A concrete loft. And also by removing the CIT roof and heightening the said walls of the said disputed room, and by constructing the first floor inside the said room, and thereafter the roof has been covered with art tiles. Thus, after constructing an additional floor in the inside of the said disputed room, the defendant has committed. Now, my lord, if your lordship will read A and C, A, they are inconsistent. Because even if we consider that C is an elaboration of A, even that is inconsistent. Because if your lordship will see, what he says in C is totally incomprehensible. Because he says that I have constructed inside the disputed room a partition wall. But that is understandable, a partition wall. And also a concrete loft. So the concrete loft has to rest on something. And also by removing the CIT roof. Now, if your lordship will kindly see, in the previous paragraph at A, he says that I have constructed a CI. And now he says that I have removed the CI and heightening of the said walls of the said disputed roof and constructing the first floor inside the said room. And thereafter the roof has been covered by art tiles. Absurd as it seems, the only thing that can be understood from all these paragraphs, that there appears to have been some addition and alteration. Now, what would it at all constitute an addition and alteration? And what have I done? Well, these are the allegations. Now, if your lordship will kindly just one relevant paragraph of the defendant. Kindly see, my lord, kindly have a look at the written statement of the defendant.
Paragraph
paragraph 9.
Hmm.
Well, there can be two ways. When I took the tenancy, there has to be, as your lordship has the written statement.
Yes, yes.
Oh, yeah. Para 9,
Hmm.
where I deal with this paragraph, paragraph 5. What do I say? Emphatically denies the allegation that the defendant has unauthorizedly made addition and alteration on the shop group and has constructed a CI roof under the such and such consent without the permission landlord and permission of the landlord previously obtained in writing as required under law. First, I am denying this alteration made. Then your lordship will kindly see my positive statement comes in the next page at page 4.
Yes.
My lord, right on top. As such, there was no occasion for the no, I think it should start earlier. Sentence to shesh hoy na hai. Tumhari jagah hai.
You leave 5 sentences, 5 lines from the top.
Well, my thing is up. It has a better copy. Ei jagah ta dekhna hai. Well, kindly see last. There is a sentence at page 3 bottom. Third defendant particularly denies an allegation that any additional alteration was made by the defendant or any CI roof under the RT roof has been constructed by the defendant as most untruly alleged.
Hmm.
As such, there was no occasion for the defendant to obtain any permission of the landlord to make alleged fictitious construction. The defendant also particularly denies the allegation that any partition wall has been constructed by the defendant as alleged. The defendant states that when the defendant took tenancy
Hmm.
of the premises, the shop room consisted of a dwarf partition wall.
Hmm.
Well, as I understand, my lord, it appears to be a short partition wall, not a wall that goes to the ceiling, that it divides a room into two halves. A dwarf partition wall and concrete loft. And the defendant has been carrying on coal shop and Modikhana shop there since inception. As such, there was no occasion for the defendant to obtain further permission. So, well, here what business I carry on is immaterial because that the tenancy was not given for any particular purpose, and it is also not that case that I am otherwise carrying on some other business in breach of the tenancy. That's not that case. So here restricting ourselves to constructions. Well, I have in the defendant in their written statement have made out a case that a existence of a shorter wall and existence of a loft at the time of tenancy.
Hmm.
Now, my lord, if your lordship will see, when the commissioner was appointed or the engineer commissioner was appointed,
Hmm.
engineer commissioner was appointed, a specific direction because this was the issue. I said that there existed a wall and it was a shorter wall. So he had to actually go and see whether the wall is a short wall or a long wall. And number two, he was required to ascertain the age of the wall.
Yes.
So otherwise, because I say it has been there and I've been in tenancy since for the last 40 years, I've been in tenancy.
Hmm.
So even when the order was passed for engineer commissioner, at least 30 years must have gone by. So a 30-year age wall and a wall which was constructed subsequently, I am sure a civil engineer would be able to ascertain. Kindly first see the report of that. But this age part, your lordship will find at page 15 of the paper. But I will come to that. But first, have a look at, my lord, the report. I will just indicate to your lordship the glaring inconsistency in the engineer commissioner's report and his evidence. Well, my and my endeavor before your lordship would be to, that based on this engineer commissioner's report,
Hmm.
could a eviction decree be passed? Because there was no other evidence before the court to come to a conclusive finding that there in fact has been a addition and alteration within the meaning of MOP, which would entitle the plaintiff to a decree for eviction.
Hmm.
Mala, the test is very high. My respect to sir, the test is very high.
Hmm.
You are evicting a person. So the conclusive finding is a matter of, well, it is, well, the test is so high because here the onus and burden principle will come, that section 103 of the Evidence Act. Because unless the plaintiff has been able to prove by unimpeachable evidence that this in fact was there, and the court is absolutely certain, well, this decree in my respect sufficient could not have been passed. But kindly have a look at the engineer commissioner's report. Well, does your lordship have that?
Exhibit, just
This would be, exhibit number would be 10.
10. Mr. Bhattacharya. Yes.
My lord, first thing, kindly see the second paragraph.
Hmm.
My lord, first he says that according to the writ such and such, I went for local inspection at such and such, prior notice upon both the parties and the learned lawyers on 17/8 and 19/9,
Hmm.
2006. The defendant deliberately, my lord, kindly make a note of this.
Hmm.
The defendant deliberately neglected to attend the
Yes.
commission. In spite of repeated requests and written notice served upon them. Perforce the proceedings of commission had to be completed ex parte
Hmm.
by exercise of power vested under Order 26, Rule 18, Sub Rule 2 of Civil Procedure Code. A well-read commissioner, very well-read commissioner. I proceeded the commission work in presence of plaintiff and plaintiff learned advocate as follows. As regard the point number 1 of Schedule 1. Now, my lord, your lordship, point number schedule. Inspected the defendant disputed room. Inspected the defendant's disputed room on the ground floor at 7 Raja Raj Krishna Street. But the entrance door
Hmm.
of the defendant disputed room as from such and such. I don't know what he means. May I just read this once again, my lord? He says, as regards point number 1 of the schedule, I inspected the defendant's disputed room on the ground floor at such and such premises number, but the entrance door of the defendant disputed room is from Madhav Das Lane, full stop. I have seen from outside
Hmm.
that the said rooms have an upper floor, and the roof of the upper floor is covered up by number of tiles.
Hmm.
So outside, my lord, your lordship recalls that Indian Army uses these glasses where they can see through walls. There are these glasses, I can't remember the name of the glasses, where they can penetrate walls, opaque projects can be penetrated and you can look through. So this was imported from a Swiss company, and there was a scam on that and all that. So we did one matter. That's how we got to know. So these are glasses. I'm sure he didn't use those glasses, but from outside he saw everything. Then he says, as regard point number 11 of Schedule 1, I observed from outside that there exist 3 rooms
Hmm.
which were partitioned by brick walls. The one middle room. The one middle room is a running grocery shop. On the left side of the grocery shop, there exists a second room, which is used as a bathroom, sitting room, and that inside the second room there
Did he-
exists.
Did he adduce evidence?
Yes, yes.
PW? What did he say?
My lord, kindly, my
How
lord,
he was
just,
cross-examined, yes.
my lord, just one paragraph, the second page of the report. My lord, kindly take this paragraph. Your lordship will see that how reliable he as a witness,
Hmm.
or how reliable is his report. My lord, kindly see the second paragraph,
Hmm.
second page. As regard point number 3 of the schedule,
Hmm.
I observed from outside from the grocery shop
Hmm.
and observing upward and seen that there exists an upper floor to be a first floor. I also observed from the grocery shop that the top of the grocery shop is made of RCC beam and the slab of the top of the bathroom adjacent such and such made of timber. I was not allowed by the defendant to measure the first floor. First you said defendant is not there, I take it ex parte, and then you say the defendant did not allow you to measure the first floor. Well, a truth. Defendant is there. Defendant is there, then he records his ex parte. No. So, my lord, truth has many ways of coming out. Made use of the first floor. I was not allowed by the defendant to measure the first floor. I asked the defendant the mode of use of the first floor. So, my lord, this is wholly inconsistent with, my lord, the second paragraph of the report, where he records specifically commission had been completed ex parte by exercise of power under Order 26, Rule 80.
Hmm.
Now, my lord, your lordship will see the cross-examination.
Hmm.
My lord, the veracity of this engineer commissioner will be evident from his cross-examination. এটা জজ সাহেবকে My lord, this is the cross-examination of DW2, which was held on 8th of May 2013. Cross-examination of PW2.
Do you have copy?
Yes, I have.
If you can part with.
I have. I'll just give it to you. I'll give it to you.
Very difficult.
Yes. May I just, this is the portion. I have received summons from court. This is the summon. Witness produces the summon. I investigated the suit premises on 2 dates. 17th August. 17th August and 19th September. Not a fact that I prepared the final report on the basis investigation done on 19th September. Not a fact that the defendant was absent at the time of investigation. Then says defendant was present. His lawyer was absent and the defendant refused to put his signature on the field note. Well, your lordship will see it's conspicuously absent in his report. Not a fact that I did not serve notice in respect of the commission work on such and such. Not a fact that no notice in respect of the commission work dated 19/9 was served upon the defendant. It is true that the commission was done ex parte. not a fact that the defendant was not present at the time of investigation. It is true that I prepared my report after watching the suit premises from outside. Not a fact that I did not visit the suit premises, not a fact that I have prepared the report as per the instruction of the learned advocate for the plaintiff, not a fact that I have prepared the statement as per instructions. Telltale.
Hmm.
And my lord, your lordship will see the schedule which was there.
Hmm.
He was specifically directed to ascertain that. He could have come back to the court, said that the defendant has obstructed me, give me police help. Nothing. And my lord, the most important aspect of the commission work was, because I say the defendant makes out a case in the written statement that there was existence of a wall and there was existence of the RCC roof. So how, in my respectful submission, would the plaintiff prove that I have constructed, when I have made out a case that when the tenancy was given to me, it was present, it was there. So, my lord, now, my lord, kindly once take section 103 of the Evidence Act.
Now, Mr. Basu, to my understanding, of course, subject to correction, when the plaintiff asserts that there was addition, alteration, primarily the onus lies upon him.
Yes.
Only upon discharging of such onus, whatever the defendant wishes the court to believe, that is to be discharged under section 103 of the Evidence Act.
Absolutely.
So, firstly, the onus is upon the plaintiff. Now, what are the points framed by learned trial court for the purpose of investigation?
My lord, kindly have a look at.
Mr. Rao, do you have copy of the petition or the order? The writ is.
Application for appointment of commission.
No, not application, the points.
Malay your lordship will find from that application the points to be looked into by the government. Just that it's
The writ is not.
My lord, if your lordship will see the trial court judgment.
Yes. Do you have the?
Which read the
There should be. A writ says a local inspection will be held. An order has been passed by this court to the effect that under order number 116. Okay, let me see 116. Where is that 116? In respect of the petition filed by the plaintiff. Okay, all your points were to be considered. Now give me the copy of your application.
No. What are the things that you do not understand?
Yes, for actually
আছে নাকি রিটটা যেটা দিয়েছিল না gifting of that.
I have given a law court's record.
Hmm?
Law court's record. Just a law court.
Law court record. এদিন তো আদিত্য these are all very bad shit. এই সবটাই দিয়ে দিন। Hold on. Perhaps it's there. Yes. It's dated 7 September 2007. Sure. Only 2 points were there: to inspect the room in suit, to report whether any permanent machinery construction have been made therein, to draw a sketch map. What about the age of the wall? Age of the construction is an important element to determine whether it was constructed.
Well, as far as the age of the wall is concerned, I think your lordship will find from the relevant instruments issued from the office of the Calcutta Municipal Corporation. A notice was issued one moment it came to the notice that they have already made a additional construction inside the showroom. The attention of the municipal commissioner, Kolkata Municipal Corporation was drawn, and they immediately issued a notice under section 401.
What
And
happened?
a guard was posted.
Guard was
My
posted.
lord,
Was it dismantled, demolished by municipality?
all of that proceeding is still pending. Because of the pendency of the suit, they could not proceed.
Okay.
Section 401 proceeding is still pending. All of the special officer already took cognizance of the unlawful action on the part of the tenant. That proceeding is still pending.
Fine.
So my lord, my learned friend's submission is that today, if there is a unauthorized construction,
And so far I'm telling you, just a minute. I'm sorry. So far unauthorized construction is concerned, but so far the report of the commission is concerned. No written objection has yet been filed against the report. Secondly, my learned friend's client made an application for recommission of the suit property. We consented to that. Your lordship will find from the trial court's record.
What is the outcome of that inspection?
They did not proceed, not pressed. Their application was rejected because of not pressed.
Simply because they had no onus to prove. Unless you discharge it.
No, not so far mine. They wanted to have the inspection.
You have to stand up on your own legs, Mr. Rao. What they did not do, that omission will not.
I have been capable of not proving. Report is there. Report is there.
Report, we were considering that.
They did not file any objection to that. No objection, nothing of the sort. And your lordship finally the.
And commissioner was cross-examined.
Yes.
That's it. What is the necessity of filing written objection?
No objection, nothing of the sort.
Is it mandatory? It will only kill time. That gentleman was cross-examined. That's okay, enough.
And the report has been marked. It is apparent from the report they constructed as many as 3 rooms.
No more on fact, Mr. Rao. Sit down.
well, only one paragraph from the trial court's judgment on this issue what just fell from your lordship. Well, kindly take page 18 of the paper book.
Yes.
Lord, paragraph starting from the top in the written statement. The defendant admitted existence of a concrete loft inside the suit property. Plaintiff's case that the defendants constructed the said concrete wall loft and thereby constructed one first floor inside the suit room property. But the defendant contended that the loft was in existence since its inception. In the case record, I do not find any evidence as to the age of the loft. No evidence has also been produced to the effect that the plaintiff took steps to ascertain the age of the said loft.
But the difficult point perhaps, so far the defendant is concerned, you kept on depositing rent in respect of one room, which was found to be practically 3 compartments. You may say that it's one room divided into 3 parts.
Kindly see, this is a dwarf wall. Your lordship is sitting there. I am standing here. There is this. Now somebody says that your lordship is sitting in one room, your lordship's officers are sitting in the second room, and we are standing in the third room. Now, if this is the my lord, understanding of 3 rooms, then there would be 3 rooms. This is exactly, it's only one
Yes.
room. So somebody comes, looks at from outside, and says first he says it's an ex parte, no. Then he comes and says from outside, he says, looks at everything. He comes to a conclusion. The court finds, the trial court finds that there is no evidence on record to suggest that there has been any additional alteration, gives a decree. Because your lordship will see.
Not at a time, please, Mr. Rao.
Only
I will
one-
come back.
only one second, very important.
I will
One-
come back to you. Just keep your important point within yourself right now. I will come back to you. I will come back to you. Don't worry. I will come back to you. I have a very fantastic question for you also. You wait.
And my lord, immediately thereafter, the next line your lordship will see the perversity why the appellate court was pleased to set aside this decree. Immediately the next line, your lordship was considering page 18. Immediately the next line, after the finding of the trial judge that there was no evidence produced to the effect that the plaintiff took step for ascertaining the age of the loft, because I make out a case in my written statement that the loft existed and so did the whatever that concrete concrete loft. Then, but there's a capital, there's a but. From the discussion in the preceding paragraphs, I find that it is admitted position that there are 3 rooms. With deepest of respect, my lord, this finding is perverse to say the least. Contrary to the evidence by the parties, contrary to any materials on a record, so the learned trial judge could not have come to a conclusion that there were 3 rooms. Lord, as we understand rooms, the definition, the English definition of the room is a room has to be butted and bounded, and it has to be a privacy. There cannot be outlets. Half constructed partition walls are not rooms. Then cubicles in an office. To separate one portion from the other. Would it make that a room? Now, my lord, kindly, my lord, with this, kindly, my lord, take the trouble of looking at the appellate court's order at page 40, which is internal page 13 of the appeal court's order. Internal page 13, running page 40 of the paper. This is on the structure part. My lord, about from the bottom. My lord, there's a paragraph starting from the bottom, about 10 lines from the bottom with furthermore. In this regard, also no evidence is forthcoming to establish that the plaintiff is true in stating in the plaint that there was additional alteration or reconstruction in the suit premises by the defendant. No document is forthcoming in the form of agreement between the Thika tenant and Bharatiya to establish the actual form of the tenanted premises, or how many rooms were let out, or the measurement thereof, or details of the internal structure of the room so let out to the defendant, that is whether there was a single storied or not having loft inside. From the cross-examination of only witness examined by the defendant, it transpires the suit room were let out for business purpose and in the present form as they are occupying. Such evidence weaken the case of the respondent. Respondent was the plaintiff, my lord. Being transpires in cross-examination defendant. The plaintiff fails to establish that there is any addition or alteration of the tenanted premises or the tenanted rooms were used for any purpose other than residential. It is also a ground for eviction in the plaintiff that the notice was duly served upon the plaintiff requiring him to vacate the suit premises by withholding the commission report fails to render help in the case of the respondent for reasons that the plaintiff cannot convince the court as to the form in which the rooms were let out to the bharatiya and purpose thereof. Secondly, the commissioner fails to conduct the commission work due to non-cooperation of the defendant as stated by the commissioner. He conducted the commissioner work from outside by PP. The court fails to understand why the commissioner did not seek the help of the court by which he was appointed. Now, this is precisely what fell from my lordship. Today, my lord, your lordship appoints special officers. It happens in our court. If the special officer faces any interference, obstacle in discharging what your lordship directs him to do, what is he supposed to do? He's supposed to come back to the court and report that I am unable to discharge my duties and file a report which would be because court cannot do. On behalf of the court, he is.
Yes.
So what's the point otherwise?
Aditya, আমার চেম্বারে না ওই বই
And my lord,
বইটা টিকা টেনেন্সি একটা আমার টেবিলের উপরে বাঁধি করে আছে।
and more so, my lord, your lordship will consider he was a engineer commissioner. He was not an advocate commissioner. He was an engineer commissioner.
No, he was appointed, yes.
The fact that an engineer commissioner was appointed, my lord, which is, my lord, 10A, if your lordship will see order 26, rule 10A, scientific investigation was required. Why? Advocate commissioner could have been appointed, like usually it is done in
For the
reasonable
purpose of
requirement
local,
matters.
yes, local inspection.
Local inspection, reasonable requirement matters. How many rooms? What is the requirement of the plaintiff? Does the defendant, to what extent he is in possession? But this was precisely an advocate commissioner was appointed with the object that certain technical issues were involved and it was required to be ascertained from the report. Because the defendant's case it was already there. So if the defendant is making a false statement, it had to be ascertained. And that ascertainment has not happened. And I have suffered a decree on the basis of that addition and alteration and nothing else.
Yes. That's all,
That's all. Great.
Mr. Raut. First, you cross the hurdle regarding your status, your locus, your authority to maintain this suit
My lord, in reply,
as Tika tenant. Yes.
my lord, so far the property is Tika property, no dispute.
Property is Tika property.
And my lord,
About your status,
my status, I have acquired ownership in respect of the Tika tenancy by way of gift.
which under the law is not permissible unless it is preceded by permission.
My lord,
That is the
my lord,
statute.
I'm telling you, lord, my lord, my first point would be, my lord, whether I have acquired ownership or not, whether I became one of the landlord or not, that, my lord, first of all, your lordship, kindly 116 of the.
No, sir,
Kindly consider.
since you have not inducted him, perhaps subject to
My
correction,
predecessor. And my lord,
estoppel will come into play only against that person who inducted you as tenant. You cannot challenge his title subject to correction.
my lord,
You just make
no.
this point clear first.
my lord, so
Who
far-
is estopped?
my lord,
Who is estopped from challenging the title of the landlord?
tenant.
Do you have evidence? Do you have evidence, Act?
My lord, supposing
No, just read out section 116, then we will move. For my understanding at least.
My lord,
Yes,
my lord,
May I have your lordship kindly?
yes,
Wait.
yes.
well, I'm reading.
Hmm,
Estoppel of tenant and of licensee of person in possession.
hmm.
No tenant of immovable property or person claiming through such tenant shall during the continuance of tenancy be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title of such immovable property, and no person who came upon the immovable property
Crucial
by the
expression would be, Mr. Raut, again subject to correction at the beginning of tenancy.
my
That is the crucial expression.
tenancy commenced at the time of my predecessor.
At the time of your predecessor.
My lord,
Now the law says
my lord,
that in order to acquire the status of a thika tenant,
my lord.
gift is all right, but there has to have a permission beforehand.
So far the permission is concerned, I am telling your lordship, although your lordship will not find from the record. Subsequently, I do have the papers, all the papers. My transfer was regularized by imposing some penalty, and my name has already been, my lord, recorded in the ticket. My lord, kindly, although
Can that be looked at in the second appeal stage, my lord? My lord, this objection, I'm sure if
My lord,
my
this-
learned senior would have been there. My lord, in a suit, second appeal stage, fresh documents being relied upon to prove a fact. But kindly,
my lord, kindly. Thika controller,
When?
my lord, it is 2017.
2017.
17.
When did you file the suit?
My lord,
at 2009, he was substituted.
well, suppose I'm holding derivative title. I've derived from my predecessor. Supposing that title is to some extent defective. Even then, in view of section 160.
You have not yet finished 116. You have not yet finished reading 116. No. What is that?
I'm
Shall be heritable.
yes,
Cancel for আমি তো ছেলে
my lord,
আমি তো ছেলে
Yes, yes, I do have the book.
your lordship kindly come to my lord.
Hmm.
Page, section 5.
Section 5,
Subsection.
subsection 5. Hmm.
Subsection 4.
Hmm.
The interest has your lordship got, madam.
Subsection 5 of section 5.
No, yes. 4, subsection 4 of section 5.
Subsection 4, yes.
The interest of thika tenants
Hmm.
holding directly under the state
Hmm.
under subsection 1
Hmm.
shall be heritable
Absolutely.
and shall not be
In this case, you have acquired by way of transfer of property. Not
Mala, I am the son. I have apart from the deed of gift, I have inherited. But all my
sorry. Remember section 23 of Hindu Succession Act,
Mala, so far,
where girls were not permitted to ask for partition. Can you remember? But if the transfer is made by way of deed of gift,
Mala,
that embargo goes.
apart from that, I am one of the co-sharer. So far, the title is concerned.
Take a constant stand. Your case is you have acquired title by way of gift and you entered into this suit under order 22 rule 10, not under order 22 rule 4.
My lord.
There is a difference between the two.
That I know.
So,
Not order 20 rule 4, order
so,
rule 10.
so
Rule 10.
you have entered under order 22 rule 10. Fine, there is no
But
issue.
your lordship, kindly
Yes.
allow me to place the
Yes,
kindly consider the language employed. in
yes,
that
yes, I am considering.
The
You
interest
read.
of thika tenants holding directly under the state under subsection 1
Hmm,
shall be heritable and shall not be transferable
hmm,
except inter se among the heirs
hmm,
and existing co-sharers.
hmm,
Interest of these co-sharers,
hmm,
interest and spouses or to the proceedings on a prospective years
Hmm.
with a prior permission to the controller.
Yes.
Your lordship is on that.
Yes,
So far the permission, so far permission is concerned, it is some sort of irregularity on the part of, but that cannot be
all
said.
I
That
know,
cannot
Mr.
be
Rao,
said.
all I know, Mr. Rao, when statute says a thing to be done in a particular manner, it is to be
That
done
is-
in that manner.
That is between the Tikadenen and the controller.
Fine.
That cannot take, my land defense client cannot take advantage of that,
Section 116.
my lord.
Read and make me understand that. That is what I am inviting you.
No, my lord, your lordship.
No, I don't know anything. A judge is not supposed to know the law. It's always the lawyer.
My lord, yes,
You
yes.
just show me and
have-
make me
We
understand.
have heard from our seniors that we shall have to argue in such a way as if judge doesn't know anything.
No, that is the accepted position.
So far 116 is concerned, your lordship kindly consider. That apart, I have already inherited subsequently because my predecessors all
So, along with your brothers and sisters,
no brothers. All I wanted, so far the Tika
what are you saying, Mr. Rao?
so
Having
far-
acquired under the Transfer of Property Act, now you are saying I have also inherited.
No,
How could you say this?
no, special provision is there in the Tigadency Act. Kindly have a look to them. And I have acquired the ownership by virtue of that. And
By virtue of what?
by virtue of the provision of the Tigadency Act, 1981.
1981.
Well, not only the new act, the transfer took place when the earlier act was in force. The promulgation of the 81 Act.
There was the same embargo in the previous.
But I do not want to interject on facts, my lord, but the transfer subject to correction happened in 2004. The gift deed is registered in 2004 and the act came into force, 2001 act came into
That's
force.
true, but that does not precede your lordship highly considered subsequently regularized and it relates back to the date of execution of the deed.
Now, what about 116?
116,
You are going to.
150, it is the principle of estoppel, a tenant.
No, I joined the issue
Well,
that it is applicable only in case of inducting landlord.
on a super inductee, there is no such 116, there is language is not.
You read
Speak
it
so.
again. Maybe I am wrong. It's you who is supposed to know the law better and make me understand.
What? My grandfather was inducting land.
He is not challenging the title of your grandfather. He cannot. 116 is there.
Yes.
But you are a transferee landlord.
Yes. What my
My contention, Mr.
Why?
Rao, when you are a transferee landlord, 116 will not come into play. You just tell me why I am not correct.
on a super deed transfer is concerned, I am not outsiders. I am not outsiders. Among one of the family members. I am one of the members of the family of my predecessor. The language is also interstate transfer.
You are on section or subsection 4.
So,
I am on section 116.
116 also kindly
You
consider.
are saying, come one by one. You are saying he is stopped from challenging my title as tenant. Right? My contention is, yes, this embargo is applicable in case of a tenant who inducted the, who was inducted by the landlord. The tenant cannot challenge the title, not the transferee landlords. Section 116 is not applicable.
According to your lordship, it applies in case of inducting landlord.
Yes,
Had this suit been filed by the, in this case, well, actually, your lordship will find on the case. This suit was filed by my predecessor in the year 1987. Subsequently, during the pendency of the suit, my predecessor died. Subsequently,
he is not questioning the authority of your predecessor. He is questioning your authority.
well, I'm coming to one, well, your lordship kindly consider. In my own way, subject to your lordship.
Yes,
kindly
yes.
approval. My lord, supposing, my lord, there is some sort of defect in my deed of gift. It was not executed with the prior permission of the FICA controller. That is, my lord, contention of my land defense claim. My lord, in reply to that, my submission would be with your lordship. That supposing, my lord, that deed of gift is to some extent irregular and defective. Even then, your lordship, I am relying a decision, my lord.
Hmm.
A tenant in possession cannot challenge the title of the, according to your lordship, inducting landlord. No. Well, in my humble submission, it is squarely applicable so far the present plaintiff is concerned.
Hmm.
The appellant is your lordship. Your lordship, kindly I am referring a judgment reported in. Well, sorry, I am grateful to my landman's land.
But he is derailing you all the time. You are trying to find out the citation, and Mr. Chatterjee has given you the another provision. Yes,
Now, it failed your lordship
yes.
that so far the earlier Act 81 Act is concerned.
Hmm.
There was same embargo with the prior permission of the municipal corporation. But my lord, your lordship, kindly have a look to that. There is no such embargo.
When did you acquire the title, Mr. Rao?
Well, suit is 81.
No. When did you acquire the title? You means the present appellant.
My lord.
We are on present appellant. I am not on your predecessor.
My lord, suppose yes, my lord, so far my suit is concerned at 87, there is a series of decisions I have brought. That suit was filed in 1987. When the 1981 Act was in force. If that be so, my suit will be guided, governed by the provision under the
81 Act.
81 Act.
Okay.
And in 81 Act, there was no such restriction in transferring property.
1981 Act.
My lord.
Paragraph, section 4.
6, subsection 4.
Section 6,
What is
section 4.
3?
3.
Subsection 3 of section 6. Has your lordship got? Well, that restriction was not there.
Yes.
Thank you.
Hmm. Hmm.
That apart, one of my alternative argument is, supposing there is some sort of defect and irregularity in executing the deed of gift. In that,
We cannot challenge the deed of gift. We are not going to challenge the deed of gift. We have no authority. Only thing is, whether by dint of that deed of gift, you can be said to have acquired the status of a thika tenant. Your deed of gift, intention of your grandfather or father to transfer the property, we are not questioning that. We are on the consequential effect of the gift over the thika property.
and my lord, so far, my lord, just now, so far this document is concerned, subsequently that has been regularized. My client, the appellant's name has already been recorded in the record of the thika tenancy. And my lord, yes, my lord, subsequently, my lord, his name has been regularized upon making payment of some amount towards the company, the penalty. And my lord, that means so far it relates back the subsequent event in getting the name mutation in the office of the thika controller. That relates back to the date of transfer. This is a settled law.
But the difficulty is I cannot peep into your file to consider the document and to come.
My lord, then you also kindly give me tomorrow I shall file an application order for 220. Kindly. My lord,
Close your argument. I have so many second appeals pending.
It is subsequent event, my lord, subsequent, that
Very-
is regularized,
Subsequent event during pendency of the first appeal.
my lord. And my lord, it relates back from the very date of my lord, execution of the deed of gift. Everything regularized. The Thika controller is not at all aggrieved by that action, wrongful action on the part of my client. So
Very-
my learned friend's client cannot take that plea. That since your title deed is defective,
No, he is not saying your title deed is
no
defective.
plea was taken to that effect. My lord, this kind of
It's a question of law, Mr.
my
Rao.
lord, that can be advanced with your lordship, since it is a question of law. But my lord, so far the title is concerned, my lord, there is no lacuna. In view of the fact, my lord, 1981 Act, there was no embargo. And my learned friend referred to the provision engrafted in the 2001 Act.
Then why did you pay the penalty?
On a penalty, because Thika control is always they are interested in getting some money in that this way or that.
Why there is no application under 226?
Government office,
Then Mr. Chatterjee should have filed 226.
government office is always ready to take money from the public. Every paper, all sorts of paper, everything. It's the penalty.
মানে আমার সুদটা 81 তো সেখানে কোনো রেস্ট্রিকশন
Any. My lord, I am referring a judgment, my lord, reported in very old judgment, 1915 ILR, page 30, Allahabad, page 557. Only here your lordship will find that it has been enunciated in that decision, my lord, that a tenant who has been let into possession cannot deny his landlord's title, however defective it may be, so long he has not openly.
That is what I was telling.
Exactly.
The person who let the property, his title cannot be challenged. Mr. Chatterjee is not in agreement with me, but yes, you are in agreement with me. Okay,
His title cannot be challenged.
absolutely right.
And my lord, your lordship is,
My question is otherwise.
since my client was not inducted, my lord, we have inherited. So far, induction is concern your lordship.
No, you have not inherited.
My lord,
You have acquired by under the Transfer of Property Act.
my lord, in both ways. My lord, suppose my lord, in
You
the
have to
absence,
take it.
my
You
lord,
have to take a stand. If had it been a case of inheritance, yes, he is stopped. Your case is something different.
by virtue of the deed of gift.
You have acquired under the act known as TP Act, not under the Succession Act.
Deed of gift, section 105.
123 perhaps.
105. Oh no, sorry, my lord.
105 goes to lease.
Lease. Sorry.
You are yes.
And my lord, in my humble submission, subject to your lordship kind question. So for the title of the appellate before lordship is concerned, the landlord
So
concerned.
according to you, that point goes. Then what next?
My lord, next point is, my lord, so far the unauthorized construction is concerned. My lord, your lordship kindly allow me to cross-examination of the deed of gift.
Yes.
He has admitted 3 rooms. But kindly have a look.
Only concession you are getting just a cross-examination of DW1.
Yes.
There will be no submission on fact henceforth, only DW1. Yes, where is DW1? Do you have copy?
My lord,
My lord, perhaps the copy that we had
Yes,
given in that.
Arjun Prasad Modi. He is the tenant. I shall be happy if you can come and lift it. ধরুন তো। 17.5 kgs. দিন এটা দিয়ে দিন, এটাও দিন, এটাও দিন, এটাও দিয়ে দিন।
My lord, well, kindly take troubles to come to
Hmm.
the cross-examination of TW1 on 3rd February 2014.
Hmm.
3rd February.
Yes.
It is true that all, well, I'm reading. It
Hmm.
is true that all the defendants reside in this wood building. Then says, my two sisters have already been married and they reside elsewhere. I cannot say how many rooms were there in the tenancy premises at the
Hmm.
time of induction.
Hmm.
Although on the last occasion, your lordship perhaps remember, and we drew your lordship attention to the two relevant exhibited documents,
Hmm.
rent control challenge and one letter,
Hmm.
which was issued at the instance of the
Yes.
tenant,
Hmm.
one room. It is true that there were one grocery shop and a shop of coal. Well, initially, your lordship will find from the plain and the written statement they have admitted. There was one room for the purpose of carrying on coal shop. And here he has admitted, your lordship, kindly have a look. It is true there were one grocery shop and a coal shop. I cannot say if at the time of inception my father used to reside in the suit premises with his family or not. At the time of inception of tenancy, I used to reside with my father. Then says, at that time I was in my childhood and a school student. I cannot remember if I used to reside at the suit building at that time or not. At present, I run a business of grocery item in the suit premises. I am running grocery business since 1987. My father died in year 2001. My father left behind 5 sons and 2 daughters. I filed in chief and well, actually, your lordship will find from the exhibit 10 commissioner's report. 3 different rooms are there. One room is being used for coal shop, one room is being used for Modi business, and one for residential purpose. Even a construction bathroom also. Well, that report was never challenged by the tenant at any point of time by filing any written objection. On the other hand, your lordship will find from the record of the case, they made an independent application for recommission of the suit premises. We agreed to that. We consented. They let the application be allowed with consent of us. But subsequently, that application was rejected as not pressed. This is the conduct of the tenant. Your lordship kindly consider.
Very well. লিখুন। Hearing concluded, reserved for judgment.
My lord,
Sorry, I can't afford any further time for this
my
matter.
lord, kindly, only half an hour.
Half an hour?
Any next week.
No, no.
Only half an hour. Only just to cut short. My lord,
Raised by which application I was added as a party amount. I was searching for.
next,
You find out and let me know. There will be no formal date. There will be no formal date. Hearing concluded, reserved for judgment. Henceforth, whatever you want to say, you give it in writing with a copy to your friend. I have many other second appeals pending.
I don't
Yes.
Do you have the deposition
My lord,
Yes.
of DW1?
Yes, my lord.
Yes.
kindly keep it on
Yes,
Monday. Subject to your lordship convenience
No.
at 3:30 or 4.
Yes, my lord.
3rd March 2014.
Yes, my lord.
7th line. 7th line. Voluntarily made. A statement made voluntarily.
Yes. Lord, that is.
That is there.
Lord, that is what is a part of evidence is
Yes.
Lord, that is something that we
Madam. Oi, had Mr. Basu, learned senior counsel for the appellant, and Mr. Raut. Hearing is concluded, reserved for judgment.
Well, kindly half an hour.
Any day you prepare a short note, give a copy to your friend and submit it. It will be taken on record. I shall consider it, no issue.
Well, at 15 minutes. Monday, 3:30, 15 minutes.
Bring, come along with your friend.
Yes.
No issue. Huh? You come
Well, he is agreeable. He is agreeable.
at any.
Wednesday. Well, then we'll 15 Wednesday.
No. Technically, hearing is concluded. Unofficially, you have been given liberty to come back.
I have some.
No, I have two. Well, kindly.
When you take your time till Wednesday, take your time till Wednesday. You just prepare a short note.
Only reason I have to be very fair enough that the staff element of justice says we belong to the same team. But we will be attending justice for
When this.
Monday is the staff element.
So go there.
That's why I was visiting if my keeps it on Wednesday.
No, I am not keeping it. It's open-ended. You just prepare the short note, bring your friend with you and hand over the note. It will be accepted. I will look into it. I am telling you. But there will be no further date for hearing.
So kindly keep the matter on Wednesday, recording the hearing is complete. For that, otherwise they will not.
Who will not come? No, he will come. He will come. He is an officer of the court.
This is not. Why will
He will come. He will come. Dakun.
Take your time.
deeply obliged?
Yes.
Hey, brother. Hey, one
Now. There are two revision petitions. Mr. Sukanta Das is appearing for the opposite parties. My lord,
Who is appearing for the opposite party?
Mr. Sukanta Das.
Where is Mr. Das?
My lord, yesterday I talked with him, my lord, over telephone. When my lord he submitted that, asked me to submit for lordship that he has some difficulty. But my lord, only the other difficulty is there. My lord, some of the opposite party have died. My lord, so far the learned advocate appearing before the trial court, but I have contacted with him. The further difficulty is, my lord, the client has taken the brief back from his. Therefore, a new advocate has been engaged. My lord, I have to contact with my client that who has died, and I have to file the application for substitution.
Who are the two? Who are the two?
My lord, most probably opposite party number 1 has died. Habibullah Khan. The instructing lawyer who is was before the trial court, but he intimated me that the opposite party number 1 has died. But subsequently, when I contacted with him and for getting instruction to file the application for substitution, he has intimated me that the client has taken back the brief from him. Therefore, I am to issue a letter to my client directly. Kindly give some time.
It is Ninto. It is submitted by Mr. Mahato that opposite party number 1 had died. So, under such circumstances, matter is adjourned to appear in the on 17th of August 2023 to facilitate the petitioner to take steps. 19 years. August 17th, August 19th, hopefully ডাকুন।
Item number 4 and 6, my lord. Mr. Anit Kumar Roki is appearing to petition.
Yes,
For his medical checkup, he could not come to this court. I'm paying 1 week's time. 4 and 6.
I have been adjourning these matters. Then where is the client? He should engage someone else.
Last time we gave 1 week's time.
No, we have been adjourning the matter on the ground of Mr. Rokhit, perhaps. Earlier also I adjourned the matter, but this cannot continue. Either he should come or something else is to be arranged.
I'll inform you.
The 18 years old matter. Next day, please take some step.
Yes, my lord.
Either Mr. Rokhit, let him appear,
Yes, my lord.
or someone else must
Yes,
assist the court, or you shall run the risk of, what should I say? You shall push me to apply my poor knowledge to dispose of your application. On the adjourned date, matter will not be adjourned anymore. Right? দেখি কত 4 and 6 কি আছে দিন তো। Why so many applications are pending? Do you have any idea?
No, I have not appearing in this matter.
Why this matter? The matter has already been adjourned sine die by Justice Basu. I লিখুন তো। In view of the order dated 4/2/2020, the matter should not be listed till the matter is mentioned after disposal of the reference cases pending before the larger bench. It is adjourned sine die. 6 নম্বরটা দিন 5 পরে কি আছে?
Item number 5, my lord. Mr. Sulindu Sekhar Beard is appearing, my lord, in the matter, but his brother's wife died on 11, my lord. I'm taking 2 weeks time, my lord.
দেখি দিন
5, my lord. Mr.
কি আছে দেখুন section
Mr.
8
Bayer
কিনা।
appeared for petition.
What's the issue? Do you know the subject matter? No.
Mr. Sulindu Sekhar Beard appearing.
This was also adjourned on the ground of Mr. Rokhit.
But advocate is not Sulindu Sekhar Beard. His relative died. Only 2 weeks time.
Opposite party number 4 died during pendency of the revisional application. No step was taken. Only the matter is being dragged unnecessarily.
The matter was dismissed for default registration on 5.
That is why whenever I am dismissing a matter for default, I am imposing cost.
Last time we did.
That is the only reason. You pay and you come. In a high court, it's very easy to get the matter restored. So some sort of difficult situation should be there, should be created rather.
Last time.
What is your good name?
Madhusudan Rao.
Madhusudan Rai. Mr. Madhusudan Rai, learned counsel for the petitioner, submits that Mr. Baird is not attending court due to some personal difficulty.
Death of his relative. Death of his relative. Others.
As suggested, the matter is adjourned to appear on Madhusudan.
2 weeks time.
No, I can. 5 number. Madhusudan. Who is Madhusudan Rai? Huh? You are Madhusudan Rai.
Yes.
And who is the petitioner?
I'm the fix.
Then you are an advocate.
Yes, ma'am.
You know when one of the opposite parties died. Opposite party number 4, you don't know. On your submission, the coordinate bench recorded the fact. Who are the opposite parties? Are they your relative?
No, not relative.
Then what's the suit? What is the suit for?
For declaration injunction and confirmation of poison.
Why you have preferred revisional application challenging the judgment? What is the judgment?
Identity note of injunction.
No,
Finish it.
bring out the application. In the matter of judgment dated 30th August 2005, passed by K. Chakraborty, learned District Judge, Birbhum. Ad interim injunction.
Yes, sir.
No, you assist the court. You are an advocate. You assist the court. Enough.
Kindly give some time, my lord, so that my advocate may.
You can't. We cannot afford this luxury of adjourning the matter.
Kindly.
This is a matter of 2005.
Yes, sir.
Now it's 2023.
Yes.
What is this? Is there any order of stay?
No,
Then
no. Suit is proceeding. Suit is continuing.
suit is proceeding. Then it has become infructuous.
No, there is the identity note injunction. There is an order of status quo.
Ad interim order,
Of status quo.
status quo is there.
Yes, sir. Only status quo is there. Kindly give some time, my lord. Then
Now, what's the status of the suit? What's the status of the suit?
local investigation commission was held.
Huh?
Local investigation commission was held,
Huh?
and that was the report was submitted.
Fine. Then
But there, my lord, division number 1 died. Division number died. His substitute application is pending.
substitution is pending
Pending.
before the learned trial court.
And division number 4 died. Trial court application for order 22 rule 10A, my lord. But the defendants are not supplying the name of the other legal years and the date of death. That's why the substitute application could not be made.
When this order of status quo was passed,
31st March
31st March?
2006.
No. March 30, 2006.
2006.
Directed to maintain status quo
Only status.
as of today.
The status quo is continuing. The suit is pending.
So let it continue.
Yes.
Let it continue. You proceed with the suit
But
and this revisional application will go. Also,
the application dismissed for default, it should be restored.
it was dismissed for default.
Yes,
When?
21st July possible.
21st?
July 2021. 2022.
2022 or 2021?
2022. 2021. July 2021.
20th July 21.
During the COVID period. During the COVID period.
During the COVID period.
Yes, my lord. And that should be restored, my lord. The Supreme Court judgment. That should be restored. my lord.
I don't find any such order. Where is that order of dismissal?
20 July 2020. The direction was passed by the Honorable Justice Himmal Bhattaji to serve the copy. The copy has already been served, my lord. The obedience service is there, my lord. Evidence service is there, my lord. I can find the evidence service, my lord. There is a delay of 7 days, my lord. August application was filed.
No, you are not. giving the correct date.
Restoration application filed on 26th August. Can number 3 of 2021.
এই দেখুন তো আদিত্য কি বলছেন ফেলে ফেলে রেখেছে এইখানে হলো July 20th 2021
And application was filed on 26th August.
application for substitution was allowed by to therefore no further order need be
Separate
passed on the said application.
Substitution of the legal years of the observation number 2, 1. Observation number 1. An application of restoration along with convention of.
Did you comply with the order of the court?
Yes.
Where is your affidavit of service?
Is it certain rule?
Was the suit all about declaration of title? Who filed the suit?
Declaration of title, injunction and confirmation.
Who filed the suit?
I plenty filed the suit. I am the plenty.
You are the plaintiff.
Yes,
You filed the suit.
Yes, bro.
আদিত্য এই আদিত্য বলছি সৌরভ বাবু কোথায় লিখুন তো থার্ড মিস্টার মধুসূদন রয় affidavit of service is taken on record. Let the matter be listed on 17th of August. (2023) under the heading for orders. I will dispose of the matter on the adjourned date.
17th August.
Either you come prepared or don't seek adjournment. পরেরটা দেখি 6 নম্বরটা কি আছে six is where is Anit Rokshit is appearing and he is representing.
6. Oh, 6 of them.
Already.
Same order করে রাখুন
Yes.
as last chance.
4 and 6.
7. You are for the petitioner.
I have the petition.
Who is for the opposite party?
কিছু নেই ভালো তোর মেয়ে নিজের উপর ধরে এসে আসুন কোনো ধারণা তো অনলাইন সার্ভিসিং ব্যাপারে না তারপরে এগুলো দিয়ে
Mr. Roy, have you served?
My lord, I have been briefed in this matter, my lord. My advocate record is also not there.
He is not available.
My lord knows very well.
Suman De.
Yes.
I know one Sumande who is used to appear in criminal matters. I don't know
No,
whether.
no, my lord, the education matter, my lord, he used to appear. My lord, here the question is, my lord, there it requires a position on the other aspect, my lord.
Hmm,
Here, my lord, section 8 application
hmm,
under the Arbitration Conciliation Act was allowed
hmm.
based on an agreement which is insufficiently stamped and not registered.
Insufficiently
Stamped and not
then,
registered.
then how it was.
Then, my
acted
lord,
upon?
that judgment, initially there is a conflict of judgment. My lord knows better than us, my lord. Now, my lord, 2023, last in the month of June, my lord, the Honorable Apex Court 3 judge bench held the SMSTT. If it is not registered, insufficiently stamped, that agreement cannot be looked into or considered to be valid for the purpose of holding arbitration. Because no clause of that agreement can be enforced in any manner whatsoever. If that be so, my lord, section 8 does not apply.
Then you have to notify the
Yes,
opposite
yes.
parties and come back.
Yes.
Ekটু নিন তো।
This is the sum and substance of this.
You just notify, I am fixing a
Yes.
date. Hey, Saurabh Babu. Mr. Roy is appearing on behalf of the petitioner. None is appearing on behalf of the opposite party. Matter is adjourned to appear on. আজকে কত? 14.
Today is 14th, my lord.
So what about 20th?
20th. Oh, so it's service order ditchen যাচ্ছে ওই জন্য। There is no direction prior direction of service.
No, now
Yes, yes, that's why, my lord.
it's a very small question of law, but it should be decided.
Yes, 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 yes.
বলুন এটা কি বললাম?
That is
Kuড়ি তারিখ, হ্যাঁ।
all are within Calcutta, my lord. Opposite matter 1 to 4. They are the defendants.
The time is enough or
20th,
I-
my lord, after 21st, my lord. Keep it after 21st July. Any date.
then 25th of July.
Get full to your lordship.
25th of July. The petitioner is directed to notify the opposite parties, indicating the date of hearing.
Yes. Get full to.
Okay. Oh. Started order আর 6 order এক হবে signed হয়. It should not appear in the list. Department ke direction দিন। Then পরেরটা ডেকে দিন, ফার্স্ট কল সব ডেকে দিন, তারপরে আমি 21 থেকে ধরবো।
Lord, I am praying for short passer. My senior is coming back. 11.
11 মানে ডান পাশে লেখা।
Wait, I am passing it over.
12 মানে Mr. Palchanda বলছে সেকেন্ড for that. Item number 12.
Yes,
I am praying for time on behalf of Mr. Palchanda.
Mr. Ghosh was very much there. Ask him to come, ask him to come. We can't afford that time.
Only not for
No, I have been adjourning. This matter is being adjourned for years together. No more.
That is, my lord, in this matter, my lord, I am appealing for the appellate.
My lord, I'm for the state led by Mr. Joyanto Samanto. My lord, kindly allow some time. He's a passover, my lord. He is on his legs, coming from Kota.
Let Mr. Roy start his case. You just take note of whatever is into. First miscellaneous.
My lord, the plaintiff is the appellant before your lordship.
Hmm.
In a suit for declaration of patent and permanent injunction, the trial court decreed the suit.
Hmm.
Subsequently, my lord, before the appeal below, an application was filed under Order 1, Rule 10 And that was allowed along with the remand. Now the constitution was that the persons who intended to be added as a party against whom a degree was passed, criticism of them from whom they are claiming title, a degree was passed by the Allahabad High Court. And my lord, whether that degree is binding upon them or not, that regard to be considered.
So
This is the
you were challenging the remand order?
remand order.
Yeah. Okay. State of West Bengal, who were
And
the added defendants?
the added defendants are the persons who have been added as a party under order of Rule 10.
They are defendant number 3 and 4.
Yes, they earlier occasion they appeared, my lord. Even an advocate represented. Last occasion when your lordship was taken, fix this matter.
Sanjay Ghosh,
Yes.
do you know?
Yeah, my lord. Predominantly it is a state,
No, state is there,
but remand at the instance of that.
Sanjay Ghosh, I mean added defendant.
Yes, my lord. Let me place, my lord. At least I can assist your lordship to some extent. Otherwise, my lord. Well, kind of Joshua paper to this. My lord, my lord will find the plaint is from page 1. I am skipping over the same, my lord. The initial page 2, my lord will find the defendants initially the state of West Bengal and the block land and land reforms officer. My lord, may I read out only the 3 paragraphs of the plaint? 3 up to 4. The properties are specifically mentioned in schedule below. Hereafter will be referred to as the suit properties. Originally belonged to Beni Madhav Bhakot, and after his death, the same have been devolved upon his legal heirs and successors, as per provision of Hindu Succession Act, and the same legal heirs and successors. While in title and possession, his suit properties partitioned the same by dint of registered deed of partition, dated such and such. And in the partition deed, the suit properties were allotted in the share of one of the sons of said Beni Madhav Bhakot, namely Shukdev Prasad Bhakot, who became owner and possessor thereof, without any connection or concern whatsoever with the other legal heirs, successors of the said Beni Madhav Bhakot. And besides his own right, he had acquired absolute right and interest and position by virtue of the possessing the same for more than 12 years, adversely to all others, and his name was duly recorded in the CS record of rights in CS Khatiya number such and such. And it was finally published. The said Shukdev Prasad Bhakot, while in title and possession in respect of the suit properties, died leaving behind his only legal heirs and successor Kedarnath Bhakot. And accordingly, as per provision of Hindu Succession Act, his legal heirs and successor Kedarnath Bhakot became the owner and possessor of the suit properties. The said Kedarnath Bhakot, while in right title, interest and possession in respect of the suit properties, died leaving behind 3 sons. My lord, from here, my lord, the 3 sons are Suraj Kumar Bhakot, Mohan Kumar Bhakot, and Ramesh Kumar Bhakot. And on the death of said Kedarnath Bhakot, his 3 sons became the owners and possessors of the rest of the suit properties in equal share. And they, while in title and possessing the same respect of the suit property by deed of registered deed of sale, transferred 1/3 share of the suit properties in favor of the plaintiff. And since the execution of registration of the said deed of sale, the plaintiff became the owner and possessor of the 1/3 share of the suit properties. And besides his own right, he has the suit property besides his own right, he has acquired absolute right title interest position by of 12 years. The said legal heirs of Kedarnath Bhakot, while in title and possessing in respect of the rest 2/3 share of suit property, transferred the same in favor of the plaintiff by dint of registered deed of sale dated 14/2/19.
My lord, may I interrupt? My lord? I am for the state. My lord, my instruction is that my lord, the appellant has already expired. They have filed a report to the district. My lord, kindly consider. My lord, the appellant has already expired.
Substitute হয়েছে তো
আমাদের কাছে কোনো complaint
substitute হয়েছে
kindly consider flag 1.
Substituted.
Yes.
No, we have no information regarding that. No.
He has been
The state is changing from yes.
substituted by four persons.
Yes.
Widow
And the sons.
Yes.
Yes, I am representing them, my lord.
I have no instruction. Maybe, but I have not.
No,
have-
এটা একটু দিয়ে দিন।
ভয় খাই দিস না তো দুম করে।
তোমার থেকে তো শেখা।
Yes.
Since execution and registration of the said deed of sale, plaintiff became the owner possessor 130 in 1997 and delivered possession of the same in favor of the plaintiff. And by dint of aforesaid purchase, the plaintiff became 16 others owner and possessor of the suit properties, and he has been possessing the same without any connection and concern whatsoever with other, and name of the plaintiff has been recorded in, though the name of the plaintiff ought to have been recorded as the owner in respect of the suit properties, but still then it appears in the LR record of rights the name of the plaintiff has been recorded as permissive possessor in respect of the suit properties, which is completely baseless, illegal, erroneous, and against the real state of affairs. That an scrutiny plaintiff came to learn that the said Shukdev Bhagat along with Odut Bihari Bhagat and Shankar Dayal Bhagat dedicated some of the suit properties in favor of Sri Sam Bihari Jew and Sri Shukdeswar Nath Mahadev Jew by dint of registered deed being number 946 for the year 1933. And though the total area of the plot number is such and such is 2 acres 8 cents, and the area of the plot 8 cents, and the area of plot number 2133 is 62 cents. From the said deed, it appears that from the said plot 2132, the total area is 2.62 acres, and from the plot number such as 7 cents area have been dedicated in favor of the aforesaid deities. As the total area of plot number 21 became only 2.08 acres, and thus the said Bhakats cannot dedicate much more property than the total area as mentioned in the said deed. And the said deed is dedicated having never been acted upon, and the said deities never became the owners and possessors of the properties. That one of the successors in interest of Shankar Dayal Bhagat, namely Krishna Mohan Bhagat, filed a suit being civil suit number such and such before the learned court of Munsi Balia, West, Uttar Pradesh, with regard to the alleged deed of Arpanama, and the said suit was dismissed against which the Shankar Dayal Bhagat prepared an appeal, being title appeal number such and such, which is subsequently transferred to the court of learned additional district judge Balia. And the learned additional district judge Balia was pleased to dismiss the said appeal with a finding that the deed of dedication mentioned above having not been acted upon. In this connection, it will not be out of place to mention here that the said Shankar Dayal Bhagat and others submitted an application of mutation with the Tahsildar cum Assistant Collector First Class Balia, which was registered as objection case number such and such, and the authority concerned, upon taking into consideration of the totality of the matter, has been pleased to find the purported deed of dedication has not been acted upon, and the aforesaid application for mutation have been dismissed. Aforesaid order has been passed by the Tahsildar cum Assistant Collector First Class Balia, having referred to the aforesaid civil suit as also to the aforesaid title appeal, and being the fact the aforesaid deed of dedication has been considered and rejected by the appropriate court of law, and as such the aforesaid deed of Arpanama is not fit to be taken into consideration. It will not be out of place to mention here further that against the determinations made by the learned appellate authority, the said Shankar Dayal Bhagat preferred a second appeal being number such before the Honorable High Court at Allahabad, challenging the judgment and degree passed in civil appeal number such and such, and the Honorable Justice such and such, by dint of his lordship's order dated 6th February 1963, he pleased to dismiss the aforesaid second appeal upon confirming the judgment and degree passed by the learned appellate court below, and the matter have been concluded by the dint of the aforesaid judgment and degree, and as such the said dedication has been made by Sri Shukdev Bhagat case to an end, and it cannot be said that suit property have been dedicated in favor of the aforesaid deities as mentioned above. So this is the sum and substance of the who is claiming, my lord, the Shukdev Bhagat was challenged. I have drawn your lordship attention, my lord, who is Shukdev Bhagat, that the three sons, paragraph 2, my lord, your lordship finds Suraj, Mohan, Ramesh. And the Shukdev Prasad Bhagat, while title possessing is also produced, that living behind his only legal heir successor Kedarnath Bhagat. The predecessor of these three sons was Shukdev. Paragraph 2 of the plan. My lord, you will also page 3. My lord, you'll find the genealogical table. But proper assistance, my lord, I'll provide your lordship a genealogical table indicating who are the persons there. Now, my lord, can I turn to paragraph 5. The aforesaid deed of dedication came to an end, but still then the authority of the state of West Bengal, without taking into consideration the aforesaid findings up to the Honorable High Court at Allahabad, fraudulently and in collusion with each other, recorded the name of the said Sama Bihari Jeev Thakur in his record of rights, which is nothing illegal and arbitrary, contrary to the actual state of affairs. And as the said deed of dedication has been declared as null and void by the competent civil court of law, and as such, the authority of the state of West Bengal has no right, authority, and jurisdiction to record the names of the said deity, such and such. Record is not binding upon the plaintiff and the legal heirs of Kedarnath Bhakut, and also the legal heirs of Kedarnath Bhakut. The Ella record of rights also name of the said Sambhir Thakur have been recorded, which is also illegal, erroneous, arbitrary, contrary to the real state of affairs. And as such, the suit property is a secular property having no connection, concern whatsoever with any deity. And as the plaintiff purchased the suit properties from the rightful owner as a secular property. And as such, the Ella record of rights is baseless, contrary to the real state of affairs. And the plaintiff purchased the secular property from his legal heirs as successor of Kedarnath Bhakut by dint of registered deed of sale. And as such, the name of plaintiff ought to have been recorded as Rayat in his property, but due to utter misfortune of the plaintiff, his name has been recorded as permissive possessor. In respect of the suit property, which cannot withstand a moment's scrutiny, and the Ella record of rights is also not binding upon this plaintiff. It is not out of place to mention here that since the declaration of the Honorable Allahabad High Court has mentioned above, nobody has challenged the said order passed in second appeal before the Honorable Apex Court. And as such, the order has been passed by the Honorable Allahabad High Court, stands within its all force and such. Nobody.
Why did you not approach the competent authority to get the record corrected?
My lord, now we are the record of rights, the cause of action, my lord knows only two things: 14x and is barred so far. I cannot ask for the correction of record of rights. Basis of the record of rights, the BLRO is disturbing my position over the property in question. That gave rise to filing of this instance suit. That is the cause of action. If your lordship may kindly consider.
Did you take any steps for correction of the record?
This is pending, my lord. That's why, my lord, litigation is pending.
Yes.
Paragraph 7, my lord, will lordship find the cause of action. Paragraph 7, page 8. And this point was taken. Now, if your lordship may kindly consider the state. If your lordship may kindly turn to page 15. Up to, my lord, the second paragraph is the narration of the facts of the plaintiff's case. My lord, got it? After that, one of the successors in interest of Sankat Dayal Bhagat and the Krishna Mohan Bhagat filed a suit being civil suit number such and such before the court of Munshi Balia West Uttar Pradesh with regard to the Alice deed of Orphanama. And the said suit was dismissed, against which the said Sankat Dayal Bhagat preferred an appeal. The entire which is subsequently transferred to the court of London Balia, and the said court pleased to dismiss this appeal with a finding the deed of dedication have not been acted upon. Plaintiff also submitted that the Sankat Dayal Bhagat and others submitted the application for mutation before the Tahsildar cum Assistant Collector. My lord, this was also narrated. Last paragraph, my lord.
No. What about the written statement of the state?
No, only.
You have not filed written statement. Okay.
On the record, I find out there is no written statement.
Yes, yes.
The authority of state of West Bengal, without considering the finding of the Honorable High Court at Allahabad, fraudulently recorded the name of the said deity, such as, and the said deed of dedication has been declared null and void by competent civil court. As such, the authority of state of West Bengal has no right to record the name. Hence, the RS is not binding upon. On this, my lord.
Now, Mr. Roy,
Turn to page 18.
You are in possession.
I am in possession. My title has been crystallized because I have purchased the property.
I am not here to declare your title because there is an erroneous record in the ROR. Because you are possessing, your possession may be protected. To that extent, you can get
the title is concerned. If your lordship,
you have to correct the record.
Record of my lord knows better than us. My lord, the record of rights is also conferred in title. It is a mere entry in the record of rights.
Fine.
So whether I am entitled to get declaration of my title or not.
You have not prayed for that.
Yes, the suit for declaration of title and permanent injunction.
The plaintiff therefore prays for an appropriate decree for permanent injunction.
Page 2, my lord.
Page 10, that is the prayer.
Page 10, my lord, is looking at page 10.
Oh, Concluding line, on declaration of.
On
the
declaration of
plaintiff.
plaintiff state.
Very well.
Now, my lord, can you turn to page 18 at the top?
Yes.
The defendant submitted, my lord, they participated in the proceedings. They submitted. LR recorder has been recording the names of plaintiff as permissive person. The plaintiff has no right title interest upon the suit property, and the plaintiff is not entitled to get a relief against the present suit as it prays for dismissal of the same. So this is the sum and substance of the argument of the state. Now, my lord, I am drawing lordship attention.
Now, what about the added defendants?
Yes. Now, my lord, can you turn to their application under order number rule 10 sub rule 2 that your lordship will find appeal. In appeal. Application টা কোথায়? না কোনটা? না সুট না পেজ 39 রেকর্ডসে আছে। এনসিআর থেকে বার করতে এনসিআর থেকে অর্ডার রুলটা। Your lordship will find the order passed in title appeal number such and such is page 39.
39.
Yes, my lord.
The application for addition of party has not been annexed to the
Well,
paper.
paper book, it is not what my landed trade is submitting under the appellate rules, my lord. Only I have, because it's the court of records or the LCR.
Everything is remembered, but that is not with the record, now. That is not the paper book.
The preparation paper book. We have to follow
Your rule is something else, only judgment, etc.
degree, memo of appeal. This because it's the courts of records, all the LCR is before this court.
You filed the application. Order 1 rule 10.
Yes. After the application.
Do you have copy?
No, in the LCR it is.
Thank you.
Oh, Josh, may find it out for your lordship.
When did you file this application?
This application was filed 13 in the order was passed by order dated 13/9/2016. It was
13/9/2016.
yes 13/9/2016 the order was passed and the application was filed on application 13/7/2016. Application filed on
13/9/2016.
2016, my lord. Huh? My lord, may I read out for your lordship?
Yes,
I have a copy. If your lordship wants, I can hand over a photo.
Give it to your friends also.
I'll get it photography after the
Yes, yes. You have prepared photocopy. and-
দিয়ে দেবো স্যার আপনার কাছে আছে না আপনাকে দেবো স্যার নেই আচ্ছা দেবো
Now, who are the
now
first?
my lord, the respond number 3 and 4 are the
Yes.
applicants.
One of them is DT,
Date.
other one.
Sevai. Two dates, two dates.
And who are the Shevaites?
Also, the dating, two datings over there.
Sevai is my lord details Bhagat. If your lordship can consider the application itself.
Hmm.
The two dates are represented by the Sevai Ritesh Bhagat.
Ritesh Bhogat is the Shevaite.
Yes.
Two seven.
One Sevai,
172.
two dates. Ritesh Bhagat
Ritesh Bhogat is the Shevaite.
Sevai, representing both the dates.
Now, Ritesh Bhogat is claiming under whom?
Hey. May I?
Just let me answer. Who is Ramesh Bhagat? Hmm?
One of the sons of Kedarnath.
One of the sons of Kedarnath. Who contested the suit in Balia?
Predecessor of the Kedarnath,
Look, there is a judgment, sir.
Sukhdev Prasad. Predecessor of the Kedarnath.
Kedarnath.
So
There is-
they are
There is a judgment saying that the Orponnama or deed of settlement or whatever was never acted upon. Now can it be reopened by the successor in interest?
My lord, the Allahabad High Court said,
Yes.
Allahabad High Court said, deeds are, where the Allahabad and property is where property. So when the suit filed in the Allahabad High Court,
Who contested the suit?
on
In Balia, who contested the suit?
Sukhdev.
Your predecessor in interest. Then it's binding on you.
my lord,
You cannot question the wisdom of your predecessor in interest in this manner.
whether the Orponnama, when it is given, when it is registered, when it is 62, then after that he is coming in the court and saying that Allahabad High Court said this, but the property is not in the Allahabad. And Allahabad High Court says it's not acted about, that is okay. But the property, how the PLR or Allahabad authority can record that property.
It was contested by your predecessor in interest. Is it correct or not?
Is correct, but can be challenged over there. That can be challenged over there.
Over where?
With Allahabad. Because maybe
What is this? What my learned friend is submitting, my lord,
Oh.
this property
Are
not.
you on territorial jurisdiction?
I'm territorial. The property, property over India, West Bengal. And the date and Orponnama depends, sir, they did allow.
This property is supplementary of the institution also.
Anyway, I will come back to you. Introduction. According to you, section 11 will not stand in the way. Very well.
I'll-
Very well. Yes.
The my lord knows better than us, some of the territorial jurisdiction can be challenged at the point of be as it may. All the properties between the parties, once this Orponnama includes this property, that's why it was brought to the and the other properties somewhere. So all the properties are included in these proceedings. And there is no, the judgment is also annexed with this paper book. There, my lord, these properties are also mentioned because this Orponnama not only restricted to these two properties, but some other properties throughout
India.
UP,
UP.
including Allahabad. So all the properties, that's why the territorial jurisdiction, and my lord knows better than us, my lord, the territorial jurisdiction can be raised at the threshold of the proceedings, not after participating in the proceedings itself. Now, my lord, if your lordship can turn to the, what is the application file? My lord, I have handed over a copy to your, my lord, has gone to. May I read out the application once? জর্জসাহেব এনসিআর মনে আছে আমার কাছে একটা কপি আছে আমি একটু বার করে জর্জসাহেবকে জেরক্স ফটোকপি করে দিই আমি বার করে দেবো
When the application was filed,
it was filed on
17th of June 2016.
2016.
Yes.
May I read out for your lordship, my lord? That the interveners two separate deities having the two separate temples situated at Dubai Chapar, Balia, Malkali, Balia, UP in such and Seva Puja of this season was commenced by ancestor of the family of the above said Ritas Bhagat out of their own funds for convenience to the family. The said ancestor constructed temples in the name of above said such and such Chabara Balia to enable members of the family to offer Seva Puja on the different occasions the cell bodies in their name. Maintaining per customs, presently the Seva Puja of these days are being performed by the Seva Ritesh Bhagat and their Seva family members having their residence way such and such. The above named that is the interveners through their sevais are making this application seeking indulgence of the court for permitting them to intervene in the person because the intervener's valuable right and interest of their properties has been severely affected and prejudiced due to the crafty maneuver of the respondent number 1, who due to obvious and oblique reason has deliberately made untrue statement in the plaint such and such, but the one willfully included the properties of these interveners in the present suit without impeding them. These interveners beg to submit. The respondent one has no right and interest over such and such. This was on the contrary, these interveners are lawful owners and possessors of the such and such, and registered by virtue of Arponnama. My lord, can you record this? By virtue of deed of Arponnama executed 30th March 1933, and registered in the office such and such. Though the LR record under Khatiyan number, name of the intervener has been recorded, but those properties belongs to both interveners 1 and 2, 800 share each. The interveners have been possessing the suit plot for more than 80 years. These interveners beg to submit such and such were never sold to anybody by the previous sevais, nor these plots ever became properties of the such and such. Willfully made incorrect statement or crafty deliberately recklessly suppress the material facts with the ulterior motive. The landed court showing the judgment of Honorable High Court at Allahabad dealing with the properties which are not subject to the aforesaid title suit number 91 of 2010, and the respondent number 1 tried to manipulate the LR record of rights. As such, the sevais of this date is filed miscase number such and such, and in the said case, I recently filed a photocopy of the present appeal. From the said photocopy, the interveners came to know about the present appeal. That the interveners are making present application, we will bring the relevant records to the knowledge of this court. So what they're claiming, my lord, if you're assuming, my lord, they're claiming that was the deed of settlement in the year executed in the year 1933. Pause there for a moment, and my lord, can you turn to
Yes.
the findings of the learned trial court on this aspect? That I am going logically turn to page 21. ডিগ্রিটা কোথায় গো? ডিগ্রিটা বলতো এই যে what was the suit property? What is the suit property? My lord will find page 28 is the suit property.
Page
28 is the schedule. My lord will find this.
28.
Yes. And I am drawing lots of for the sake of repetition, my lord. Page 21. The original owner of the suit property was Beni Madhav Bhagat. And after his demise, his legally has partitioned the suit properties amongst themselves by registered deed dated such and such. And the suit property was allotted to the share of Shukdev Bhagat. And his name has duly been recorded in the CS record of rights. And after his demise, his only legal heir, Kedarnath Bhagat, inherited the same. And after his demise, Kedarnath Bhagat, his 3 sons, Suraj, Mohan, and Ramesh Bhagat. My lord, here, my lord, your lordship find his claiming title to this Ramesh. No position, this was suit property, and later they transferred the total property in favor of the plaintiff by dint of 2 registered sale deeds such and such. And thus the plaintiff became the owner of the LR, but the LR record name of the plaintiff was recorded as permissive possessor, not riot. Erroneous, and skipping over the same. The predecessor interest of the plaintiff, 1. Oud Bihari Bhagat and Shankar Dayal Bhagat dedicated some of the suit properties in favor of Sri Shyam Bihari Jiu, Sri Sukhdevnath Jiu, by dint of registered deed being number 946 for the year 1933. The same deed, my lord, you find from the application it was mentioned. But later on success interest of one of the executors of the said deed, Krishna Mohan Bhagat, filed a suit being such and such. He was the learned court of the Munsi Balia, Uttar Pradesh, regarding the alleged deed of Arponnama. And the said suit was dismissed against which an appeal was preferred by title, which was transferred and Judge Balia. And that appeal was also dismissed. Second appeal was preferred with the Honorable High Court at Allahabad. In the second appeal, the judgment and deed was affirmed. So it was held that the deed of dedication made by Shukdev Bhagat, Aud Bihari Bhagat and Shankar Dayal Bhagat was not acted on by the state of West Bengal without considering the finding of the Honorable High Court at Allahabad recorded the name of the said deity.
My lord, next matter is my matter. My lord, 1 p.m. one matter is fixed before the Honorable Justice Amrita Sinha. If your lordships continue this matter, my lord, may I leave?
You may leave, but I don't know how long it will be continuing.
My lord,
You are absolutely,
if
you are absolutely free to walk out.
if it's called, chali jao, actor.
How will? Lunch how will?
how.
Recorded the name of the deity Sri Sam Bihari Jeev Thakur, RS recorded in respect of the suit property. And on the basis of the said RS, LR prepared, that was described permissive position and the said name of Sri Bihari Thakur was recorded as a Rayat. On the basis of the recording, defendant is denying the title of the plaintiff over the suit property and threatening the plaintiff will allow not to possess the suit property. And the plaintiff cause of action to file the present suit. So what submitted to your lordship, this is the cause of action. 14x was taken, but not is a matter of title, so 14x. Now, my lord, the finding to that aspect that our lordship exhibit 5, last paragraph of page 23. My lord is reading the entry. Shows that it was held by the additional civil judge Balia that the gift deed executed on 19/7/1930 in favor of the deity has not been given effect. And exhibit 6 shows that the above findings was affirmed by the Honorable High Court at Allahabad. In the second appeal, by combined reading of exhibit 7, 8, 9, I find that the title was passed by the plaintiff from the original owner of the suit property as the Zarpan deed exhibit 2 declared was not acted upon the High Court at Allahabad. So this is the specific finding. The predecessor of the applicant also contested the same and ultimately up to the Honorable High Court of Allahabad held that deed was not been acted upon. And now if your lordship want, I can place the second appeal. Which was filed for the page number to bolte ekটু okay 35 yeah 35 if your lordship may draw your lordship attention page 35 part 2
Part 2
that is exhibit 6 part 2 8 is at the back portion my lord
page
36 এটা কি পড়া যাচ্ছে না দেখি দাদা
Mr. Roy,
it is
just let me draw the family tree.
yes
Beni Madhav, that is the starting point.
yes
Beni Madhav,
Many
then
other pocket.
Beni Madhav was survived by
3 sons
Beni Madhav, then there was a partition
amongst themselves
and the suit property was allotted to
Shukdev
Beni Madhav had 3 sons.
many other 3 sons
They are
Shukdev no এই যে
no Shukdev was the
Beni Madhav Shukdev allotted to one of the sons of Beni Madhav name Shukdev Prasad Bhagat Shukdev 3 sons
No,
so far the
Shukdev-
Beni Madhav from only we are getting Shukdev
Beni Madhav was the original owner.
owner. After that one Shukdev came
Partitioned with whom? Don't know.
that
Shukdev was allotted the property in
Property.
suit.
Yes.
survived by 3 sons.
No, Sukhdev only by one, Kedarnath.
Oh, Sukhdev by Kedarnath. Kedar had 3 sons.
3 sons, Suraj, Mohan Kumar, Ramesh Kumar.
Suraj, Mohan, Ramesh. Yes.
This Ramesh is the predecessor interest of who has present Sevai to file this application.
So Ritesh,
They are claiming to Ramesh.
Hmm.
This branch.
Ritesh. And the deed was executed, deed of
Settlement, my lord.
Suraj Mohan Bhagat.
Yeah.
They transferred the property.
Yes.
Suraj Mohan and Ramesh Kumar.
Yes.
They also transferred the property to you.
Yes. All the years. 2 separate deeds are there, my lord.
Plaintiff by
One
itself.
is
Hmm.
1991,
Hmm.
6/11/1991. Another is 14 February 1997.
Ramesh is claiming under Ritesh. Ritesh is claiming under
Ritesh.
Ramesh.
Ramesh.
Ritesh is the Shebaet now.
When the predecessor Ramesh executed the deed declared to be secular, how the successor can deny the title of Ramesh? I put this question to myself.
No, it's a question, section 8, you have to answer that. Section 8 of TPF. I will come back to you. These are the questions. As popping up, I am passing it to you.
3 provisions, section 11 of the Code of Civil Procedure, section 40 of the Evidence Act, and section 8 of the
TPF.
Transfer. These are the 3 provisions which I want to argue. This is the appeal which was filed, my lord. I'll get it legible copy, my lord. Your lordship kindly consider there these 2 deities were the appellants. Where, my lord, your lordship find last page 40, the permanent lease of the land where plaintiffs are described and they are acquired the bhumi of the right, and the defendants were in cultivating position such and such. They should not be that the same. They could claim the Adivasis as well subsequently became the Siddha. The relief claimed by the plaintiff could not therefore be granted to them, and the suit is rightly to be dismissed. At the instance of this deity, this suit was filed. Now, my lord, whether these properties were there in the said proceedings or not, that my lord will find. এখানে আছে এই যে
Who was Kishori?
Kishori. Another branch, my lord. Kishori.
No. Whether he was claiming.
I'm claiming to.
No, I'm not on your claim. This
applicants.
No, Krishna Mohan Bhagat, who challenged the deed of settlement. He was claiming under whom? Krishna Mohan filed this suit.
Yes.
Who was he?
Krishna Mohan Bhagat হচ্ছে yes. Second appeal করেছিল তারা। এক মিনিট। Page, your lordship, I will turn to page 107. Krishna Mohan Bhagat. ওই ইয়েটা কোথায় গেল? হ্যাঁ? Shankar Dayal. My lord, the appellant number 4 before the court below, before the Allahabad High Court, Shankar Dayal Bhakot, his successor was Kishori Bhog. One of the successors.
No. This second appeal. This second
appeal, my lord, this second appeal arising out of refusal to mutate the name of in favor of the Shebite.
In favor of the Shebite.
That is the ground for second appeal up to this, because there is a rejection against that appellate authority was.
In order to invoke the provision of section 11.
I draw lordship of the additional district judge civil court's jurisdiction.
Yes.
Yes.
And that suit was filed by Krishna Mohan.
Yes. That the legal heirs.
What is the correlation between Krishna Mohan and this Bhagat?
Yes, Krishna Mohan is the successor of Shankar Dayal Bhagat.
Shankar Dayal Bhagat.
Yes.
Krishna Mohan filed this suit.
Yes. That your lordship will find at page 22. Well, may I read out for your lordship, then it will be to some extent.
No, that I have found, but where is the document? Have you annexed the document? The plaint?
Plaint
Plaint or judgment?
Yes, page 22, part 2. Huh? Page 8 is the trial court judgment.
No. Page 8 is the trial
Court judgment. Well, let's keep on because
parties don't appear to
part
be
two,
identical,
part two.
Mr. Roy.
And page 22 is the appeal court judgment.
Bachchan Rai and others.
Yes. Shambhari Narayanji and
Is
Shiv Bachchan and others.
Shambhari Narayanji is the DT plaintiff.
Plaintiff.
Now, what was the suit for?
Suit for, my lord, declaration that the plaintiff, one set of the plaintiff and two set of the bhumidars of the plots in and permanent injunction for restraining the defendants or interfering the position instead of the plots in suit and alternately recovery of possession if it was found the plaintiffs are not in possession of the property. Page 22, my lord, it is legible, my lord, I am reading out because this is the crux of the entire matter. Page 22.
No, what has been written in page 22?
Yes.
There is a mismatch apparently, subject to correction, of course. In page 22, it is stated that one of the successors in interest of one of the executors,
yes,
that is Krishna Mohan Bhagat, filed a suit being civil suit number 255 of 1955.
Yes.
But 255 1955 is filed by the DTs. And there DTs are claiming title over the suit property. And your statement is declaration that the settlement deed was never acted upon.
Yes, the case of the plaintiff is ancestors of the plaintiffs were permanent lessee. Plot number within the rights transfer Sukhdev Prasad, father of the plaintiff number 3, Adil Prasad Bhagat, father of the plaintiff number 5, and Shankar Dayal Bhagat, plaintiff number 4, executed a gift deed that 1933 in favor of the plaintiffs. 1. Set in respect of the property in dispute and some other property, and since then the plaintiffs once it became the permanent lessee, and after Act 1.
You are reading
Page 22, the appeals court judgment, my lord.
Page 22.
Yes, my lord. Part 2, page 22. The case of the plaintiff, my lord, will find. The case of the plaintiffs.
Yes. Now, part 2. Who are the parties?
That the deity,
Shambhari Narayanji, the plaintiffs who lost the suit,
yes,
who prayed for declaration of title and permanent injunction. Having lost, they preferred this first appeal.
And it was held that the deed was not been acted upon and the title was plaintiffs were permanent lessee. My lord, may I read out?
Appeal is dismissed.
There is no appeal preferred. So the issue decided between the parties.
Between the parties. Now, who are the parties? Now,
yes, the degree is there, my lord. That's why, my lord, may I read out? The
no,
plaintiff.
Shiv Bachchan Rai.
No, who are this? That is narrated in paragraph 23, my lord. Your lordship kindly consider.
Paragraph-
Plaintiffs, paragraph 20, page 23 onwards. Plaintiffs were the permanent lessee of the plots in suit with right of transfer. The Shukdev Prasad, father of the plaintiff number 3, Avadhi Bihari Bhakot, father of the plaintiff number 5, and Shankar Dal Bhakot, plaintiff number 4, executed give deed on 19/7/1933 in favor of the plaintiff number 1, set in respect of the property in dispute. Some other property, and since then the plaintiff one set became permanent lessee, and after Act 1 of 1921, they are the Bhumidars. That is the village record, the name of the plaintiff number 2 set record and the name of the plaintiffs 1 set were not entered. The plaintiffs number 2 set, who were the manager of the plaintiffs number 1 set, had acquired Sonod and Bhumidar in their names after depositing 10 times rent, and all the village records and number of the plaintiffs number 2 were recorded. And in fact, the plaintiffs 1 set were in possession of the plots in suit through plaintiffs number 2 set. Who are the managers? They are the permanent lessees and the right of transfer. So it is not necessary to deposit the 10 times of the rent in order to acquire Bhumidari's rights. That the defendants have no concern with the plots in the suit and were never in possession of the same. That the plots in suits were in possession of the plaintiffs number 2 set, and the defendants are in collusion with the village Patwari, and they have filed objection in the correction of the papers, which was started for the entry in the names of the plaintiffs sets, and the plaintiffs come to know the defendants have got their names wrongly recorded in correction papers such and such. It is summarily held by the revenue court that the defendants are in possession of the plots. The defendants have filed the written statement and stated they have pleaded that plaintiffs were not in possession of the plots, and the suit was barred by limitation. The defendants are in possession of the plots and the last 7 years or 8 years. Then they are in possession of the plots in the suit plot number and acquired Adivasi right, and now it has been held by the revenue court that the defendants were in Adivasis in the plot suit. The learned Munsi were held that plaintiffs 1 set were not owners of the plot in dispute and are not in possession of the same. They further held that after enforcement of the Act 1950, the plaintiffs ceased to be the Bhumidars of the plots. This was that they became the Siddhars. According to the device, dismissed the plaintiff suit. The plaintiffs have examined Kedarnath Bhakot, Ramjas, and Parishnath to prove their position title in respect of the suit plot. They have filed Exhibit 1 copy of the sale deed dated such as executed by Kedarnath Bhakot in favor of Shiva Prasad Bhakot in respect of the plot in suit. Exhibit 2 is the original respective mortgage deed executed by Kedarnath in favor of the Nidhi Mishra in respect of the plot in suit number. Exhibit 3 and 4 are the permanent lease in respect of the plot number such and such. Exhibit 5 is the original deed dated 13th March 19. Exhibit 6 is the copy of the order dated 19/3/5/1954 passed by the London Additional Commissioner Banaras Division in appeal such and such. This is the Shonod of Bhumihari rights. The defendants have examined Giridhar's theory, Virendra Mishra, Shiv Bachchan, and Sitaram to prove they are in possession of the plots in suit. They have filed Exhibit A and Exhibit 2 to receive to show payment of rents to such and such. And the defendants are recorded as maintenance of the plots in question such and such. This is Khatayan, which the defendants are recorded and Adivashis. Such and such extracts. 1937 has been filed to show that the defendants were recorded position in the plots in suit, column number such and such. Fasil is not respect of the plot suit. Exhibit A is a Khasa extract. Keep over the same from the findings. I'm coming to the state to the finding. If you lordship. আমাদের সুপ্রপার্টি এটা আমাদের ওই অরিজিনালি এটা কোথায় হ্যাঁ কিন্তু না আমাদের সেটা সেই ইয়েটা বলছি
Mr. Roy, how to infer that the settlement deed was not acted upon, it was the judicial verdict? Where is that finding?
Yes. এইগুলো একটু এই যে exhibit 7 is the your lordship find page 42. এটা হচ্ছে ডিডটা হ্যাঁ এটা পড়া যাচ্ছে না এটা
Page 42 is the
deed
certified copy of the deed written in Bengali
Lordship can find out that he equal. I couldn't find anything from my whether it's a fake or Hebrew.
এইখানে যেটা আছে কিন্তু এই ডিজিটাল পোর্শনটা এটা রেকর্ডস চেক করতে হবে so far the judgment which is there at 255 and 1955 this was relied upon সেই প্রপার্টি গুলো হ্যাঁ কিন্তু অর্পণ নামাটা করতে অর্পণ নামাটা ডিক্লারেশন করতে এটা 93 ইয়েতে ইয়ে পেয়েছে অর্পণ নামাটা না ইয়ে করতে পারলে তো বোঝা যাবে না কিছু This is the Orponnama which is created.
And
Or Orponnamata equal to টাইপ করা কপি আছে না এটা জজ সাহেবকে দিতে হবে পেজ 117 your lordship find page 117
now, is it correct? Your title deed is at page 80,
page
80 of your part 2,
my title deed
your title deed.
এটাই তো
Is it your title deed?
yes
Sheikh Nazrul Haq is
yes
it? Now, your vendors, they are representing the deities.
is
How
this,
could you,
this is 91 93 two deeds are there that's why my lord no
let's go one by one.
yes
So for 91 deed is concerned, the property of the deity was transferred in favor of your client.
yes
And perhaps, I don't know, it appears Operation Borga was responsible for such transfer. Maybe. Ceiling limit, etc.
না না এইটা প্রপার্টিটা জসেফের মতো যে ইনিশিয়ালি তো যেটি বর্গ অপারেশনের জন্য বর্গ অপারেশনের নন এগ্রিকালচার মানে because the property is not
There is, I have to read it between the lines.
Yes,
There
yes,
is some reference. You are the Borgadar, you have been cultivating, we are not getting anything. So we are transferring it. That was the common way to bypass, yes.
Save the ceiling limit. Page 90 your lord shall find page 91 my lord
Yes.
the same plot this is there my lord your lord shall find it was declared to be secular property and on basis of which it was transferred 90 there my lord the Ramesh Kumar Bhakot one of the signatories
I don't think same property was transferred twice.
yes same plot from 1/3 my lord by the earlier deed 2/3 by the rest deed so these plots which are
Same plot but different properties.
same
Same
plots
plots.
1/3 1/3 1/3
1/3 was owned by,
no three brothers
they
everybody
initially transferred 1/3,
1/3
then rest 2/3.
rest 2/3
Then how a Devotar property turned into a secular
Secular
property?
that is my lord
Once Devotar, it is,
always that is
Then-
why
then
that is why if the deed on basis of which it was challenged because it is transferred in 1933 and after 1933 these deeds only on the basis of that dedication deed of dedication 1993 created by that person
which did?
that the 1933 deed
Now you show me the document by which
the
This
properties are also
deed of
involved in that declaration
this deed of settlement was held to be invalid or
Yes.
not acted upon. Show me that judgment. Where is that judicial verdict?
Allahabad High Court. Well, may I come back to next week?
You want to come back when?
Sure, tomorrow.
No, Shiva,
From this onwards, my lord, we have to go line by line.
no, when?
As your lordship pleases. It is not our.
Your vocal cord is not that strong like me. So you come and take the mic. Take the mic. Oh, that's fine. That's why you are praying not today.
জশা যা বলবো আমাদের বলবো কি সবাই These paper books are regarding filed with the department. Department used to circulate by law.
You collect it. You collect it. It must be there.
If my land is I can supply a spare copy. একটা কপি আছে কিছু নেই
Now, fundamental question is, you need to show me both. I'm just counting out state from this. The deed of settlement was declared inoperative by any competent court of law. That is the foundation of the claim of Mr. Roy. Now, one deed is saying something else. The other one is a secular deed. Then question comes, Mr. Roy, how could a Devutta property convert into a secular property? That you need to explain. So you need to show me the judicial order.
And the involvement of this property in the said case, in the said judgment. If my lord that by admission title cannot be conferred, my lord subject to question, my lord. If somebody says it is a debtor's property and transfer the same.
You have,
Prior to that, if the declaration is made that
yes, you need to show me that.
that is the thing. That's why, my lord. Now, three things I have to show subject to question, my lord. One, what is the issue before the civil court regarding declaration of that Orpon-nama, basis of which these dedications were made in respect of the suit property.
Civil court at Balia.
At Balia, whether these properties are included in that Orpon-nama or not. What is the issue? Who are the persons who are the intended proceedings? And what is the outcome? If the findings, my lord knows whether if the appeal, then my lord order 41 rule 22 is there. If that not been taken care of, then my lord, to what extent they can set up their new case when it was declared to be invalid? Well, that is.
Let's first see that it was declared to be invalid. Then that question.
That is the thing. If it is not declared to be invalid, I have no case at all.
So,
as you lordship,
suggested it. I will be here from 10:30 from Monday next also. I have no plan to.
No, Monday, my lord, I will be not here. Well, no.
So you suggest a date.
Only not on 21st July. 21st July.
But 21st July would be the ideal date. You know, there will be none. There will be none. You come.
We used to came, my lord, before at night 8 or 9 you cannot reach to there.
So we will continue hearing till 6:30.
Yes.
With a break of coffee intermittently.
Mr. Roy will lose another fee. That will be counted with a single.
Let's say the advocate civil matter করি আমার ইয়েতে ফি দেয় কবে দিয়েছিস হ্যাঁ এই 21st and Monday
Except 21st.
Saurabh Babu.
Sorry, on the 26th.
Heard Mr. Roy, learned counsel for the appellant, Mr. Samanto, and yes, what's your good name, sir? Mr. Sanjay Ghosh.
I have already supplied a paper book.
Learned counsel for the respondents. So, let the matter be listed for hearing on. কিন্তু আদিত্য কোন সময়টা দেখুন তো একটু কবে একটা ডেট বললো না একটু ফাঁকা আছে
Except Monday, my lord. Except any one.
No,
Except any one.
This Monday.
You don't stay in Calcutta on Mondays.
I used to stay, my lord, where we will go.
I'm
in native place, my lord. Few days back, my lord, is in the Gram Panchayat.
Special.
Bamiyat?
No, it's special. It's special.
Special reservation.
listed ডেটটা ফাঁকা রাখুন দেখি for further hearing.
Grateful to your lordship.
Let me 26 26th of July.
Lord, with regard to item number 15. Lord, your lordship heard this matter on my behalf. Mr. Aniruddha Chatterjee was the respondent. He will not be able to come.
Of course, he
I
will not
walked
be.
with the other side, my lord, if your lordship fix it on 2nd or 3rd August, they will not be in difficulty. Or 4th August.
Where is his junior?
Papi Junior to us. Lord, I would intimate them, because I will talk with them.
কুশল ছিল একটু।
হ্যাঁ
হ্যাঁ।
ওটা একটু মার্ক করে রাখুন 3rd August.
And the interim order already granted till 27, 20 of July, may be extended till 2nd or 3rd, till hearing.
My lord, one.
Then you come back on Monday, I will pass judicial order. Not now.
My lord, may I
Yes,
pray
my lord.
one thing? Hardin part.
Yes, hardened part, it will appear as parted matter for further hearing. Yes.
Then, my lord, I shall,
Send someone on Monday, let him mention, then let it run as not today. On Monday, I shall pass judicial. আর কি ফর অর্ডারস গুলো নেবো তাই তো আফটার ফিক্স পয়েন্টের কটা আছে বাবা। চোদ্দ অনওয়ার্ডস না স্কিপ করুন আমি দুটোই বসবো 2:50 তারপরে ডিভিশন বেঞ্চ চলে যাবো তার মধ্যে থ্যাংক ইউ
Madam, the petitioner, my lord, this is an application for execution of a, I'm sorry, madam.
Cancellation of
This is an application for execution of a consent partition decree, my lord.
consent partition decree.
My lord. My lord will kindly take
You
up
mean
my-
to say final decree has
final
been drawn up on consent?
My lord. Yes. I will, in respect of this decree, my lord, there was another execution application not filed by me, by my learned friend, my lord. My lord, and in that, my lord, may I just hand over the judgment, my lord?
বলেছে একই ডিগ্রি কতগুলো execution
But
why multiple execution proceedings?
but this is a partition suit. There are many parties. My lord knows that in a partition suit, the plaintiffs and the defendants have the same status. My lord.
Fine, but why multiple execution proceedings?
This was filed by.
My lord, there is
Yes.
appeal pending against this.
No. There is no
There is an
stay.
appeal also
There's
pending.
no stay. There's no stay, my lord.
Directed
may
the
I
corporation
explain?
to take the necessary steps and file a report.
One by
No.
first
Just
let
apprising the my lord.
Since it's
About
my
the-
application, may I apprise my lord of the facts, my lord?
no first let me understand why multiple execution proceeding
but-
against
but,
single decree.
May I?
Yes.
My lord. But my lord, my lord, what has happened, my lord? There are many parties, my lord.
Yes.
In this partition suit, my lord. The decree was passed in the final form by consent, my lord.
Fine.
Thereafter, that decree was not complied with.
Possession has not been delivered in terms of
Possession
final
has not been delivered, but although it has been partitioned by metes and bounds, possession has not been delivered.
Fine.
So, my lord,
Why multiple execution proceeding? That is my sole question.
my lord, may I, my lord? My lord, there are multiple parties to the proceedings, my lord. In regard to their possession, my lord, they had filed an execution application which took care of their.
Are you opposing that?
No, I am not by any means opposing that. I am supporting that. I was supporting that all along, my lord.
My lord, may I submit? for
Yes.
comment? There was a partition suit between three brothers.
Fine.
My lord, the suit was decreed on compromise.
Fine.
Final decree has been passed.
Fine.
Appeals preferred.
Compromise degree, then
Yes,
why appeal?
multiple appeals preferred by challenging the report of the commissioner for asking of receiver and multiple.
Then why you are saying it is consent
My lord,
decree?
my lord, may I submit, my lord? All appeals were filed by original defendant number 1. Then, my lord, all the appeals were dismissed by an order of the division bench in 2012, December. And my lord, the division bench held that the decree is affirmed. Then, my lord, I defend the plaintiff. I am for the plaintiff. Yes, one of the brothers had filed an execution in 2014 for executing. There are 3 lots of the properties: lot A, lot B, lot C. I am the owner and occupier of lot A.
Yes.
I have
So
filed.
lot A has been allotted to you.
Yes, my lord, I have filed an execution process.
Yes.
In 2014, the judgment just being handed over to your lordship. In that proceeding, my lord, original defendant number 1 taken out an application under section 47. That application was dismissed by a coordinate bench of this court.
Fine.
Thereafter, my lord, I moved this matter, my lord, in 2000 after the pandemic, my lord, before his lordship, the honorable, before a coordinate bench.
Fine.
A judgment has been passed by granting some beliefs as per the tabular statement, affirming the decree. And my lord, the defendant.
Judgment pursuant to the judgment final decree was drawn up.
Yes.
Now you put the final decree into execution.
Yes.
All you need to do is to get someone appointed. I don't know, special officer or commissioner.
That is
My
my
lord, there is a receiver in my execution. There is already a receiver in respect of lot A.
What is?
I am lot.
Why receiver?
My lord, receiver appointed for pegging and demarcating the properties.
Receiver to demarcate the property.
Yes, and by pegging,
Fine.
demarcate my portion, lot A. He is dependent number 2, another brother. He filed a separate execution proceeding for demarcating his lot.
That is
And
lot
my
C, my lord.
A decree,
Yes,
one decree,
yes.
that is to be executed to the fullest satisfaction. Then the lease will come to an rest.
My lord, my lord.
Am I correct?
Yes.
Then how there could be multiple execution proceedings?
My lord, subject to correction, my lord, since we are two separate parties, probably there is no bar. So in file,
What's the necessity?
but
When the decree is put into execution,
my-
you get your property.
My lord. May I, for a minute, my lord, what has happened, my lord, in his execution application, he has asked for demarcating and taking over possession of lot A, my lord, which is marked in a map. I can
Are
hand
you a
over.
party
My
in
lord,
in that execution?
yes, I am a
So
party.
you file an application for allotment of your part.
He could, my lord, but he chose to file a separate application.
Is it maintainable?
My lord,
That is, my lord.
subject to
Execution
correct.
proceeding is
My
maintainable.
lord, subject.
Position, my lord, that is in the compromise decree.
This is the
Can
second.
compromise degree override the provision of law?
No, that it cannot override the
You have
provision
to
of law.
show me multiple execution proceeding is permissible to execute a particular decree.
My lord, there are 3 lots, my lord.
Maybe one decree, please understand.
One decree, my lord, but the parties
You are not going to execute the lots. You are
I-
going to execute the decree.
My lord will kindly appreciate, my lord.
No, you first clarify me on this. Then I will get into the other points.
There are other.
You are also there. Wait, let your friend first try and yes. My dear friend, point is very clear. You have
My lord
a
will
final
keep
decree.
it tomorrow. I'll
You have
come
a
with
final
judgments.
decree. You have a final decree
Right.
passed on consent according to you.
My lord. But
Now-
I can show from the papers.
No, fine. Admitted positions. There is a compromise decree.
Right.
And you have put the decree into execution for
Right.
allotment of your share or delivery of possession in terms of final decree. Right? That decree was put into possession by your friend.
My lord.
You were a party to that proceeding.
I am a party to the proceedings, but when it comes to my plot of land, it is lot C. When it comes to his plot of land, it is plot
Very
A.
well, lot A.
And in his execution application, he has not made any prayer in regard to lot C. So I had to make an
You
independent
make
app-
your prayer over there. Where is the
that I could have, my lord, but I have preferred a separate.
you show me law permits you to.
I will kindly keep it tomorrow. I'll come with judgments, my lord.
Tomorrow.
I'm sorry on Monday, my lord. I'm extremely sorry. The next.
Next Friday, even next Friday, I mean, criminal matter. Yes,
My lord,
My
my
lord,
reference starts.
I am not entering into merit. First, you need.
For a minute, my lord. Just for a minute. My lord, I know, my lord, what is gonna fall from him. There is no decree. There is no decree, my lord. I should apprise your lordship. Before it starts, my lord, I should apprise your lordship. There is no.
My query is first, you show me multiple execution procedures. That is point number one. Then if he is challenging the executability of the decree, according to him, there is no decree. I will listen to
my lord, if my lord wants, my lord will kindly keep it on Monday or any day, my lord.
not Monday. Aditya Babu,
I'll come with judge.
কি অবস্থা? দেখুন কবে দুটো থেকে Monday at 2.
My lord, great.
Yes.
Subject to my knowledge.
He can argue on Monday, I think. If my lord is asking on me.
Are you receiver? Oh, you were appearing in person.
Since my lord 2007.
Since 2007, and it is his case that the decree is not there.
Okay, have some patience. Yes.
Yes, submit now. The order passed on 2nd March in the other execution case this year. I have prepared an
That appeal was heard on 23rd June.
Hmm.
The honorable division bench decision over the matter, not only that, they indicated the stand of the corporation, Calcutta Municipal Corporation. For that reason,
Calcutta Municipal Corporation, how comes into the
Yes.
picture?
He start, it will linger. What I am on is this one subject to my lord's kind concern. The honorable division bench was pleased to direct the municipal commission
Hmm.
to file a report before this court, that is before the honorable division
Hmm.
bench. In a period of 4 weeks,
Hmm.
although that order has not yet been half.
Oh, that is municipal commissioner and the court. I am not on that. Yes.
Now the issue centralizing the only part, this is our dwelling. Our predecessor has filed the petition in 2005. That was,
So now cousins are fighting.
now my lord, we are now equal owner of the property. See that as it. Now since they want that our predecessor, whatever has done, good, bad, indifferent, they want to get it. Now it is our dwelling. Now this property is lot A. We are falling under lot B, having no amenities.
No amenities.
From ground to fourth floor. Lot A, lot C practically having one, but subject to some construction, their lot will be having. But we are having nothing on record. For that reason, this honorable court engaged on 11 January 2010, the Calcutta Municipal
Oh,
Corporation.
Mr. Bhattacharya, sorry. Is there any appeal challenging the final decree?
No.
Appeal challenging final decree in that sense is not there.
Okay.
Now the point, there are several issues. In fact, simultaneously defendant number 2 here is on record. This is defendant number 2 is on record. That is also so many points are pending before the appeal court. So you will not hear this matter on Monday or onwards. Practically the pending issues before the honorable division bench may be frustrated, subject to correction.
I am opposing this. I am opposing this prayer.
No, over the identical matter. That cannot be.
Identical matter.
No, no, no.
Arising out of the self-same decree.
No, no, no.
Self-same
Self-same
Then
decree may be there, but
better, why can't you move and obtain some order of stay?
yes.
My lord, that is the court by several orders in earlier execution case tried to compromise the matter by directing corporation. What the corporation did based on the prayer of the plaintiff and the defendant number 2 years without they getting substituted themselves in the proceeding, approach the corporation immediate after the decree for apportionment of the property, which is not permissible under section 178 of the case. Now, thereby, whole construction process has been stalled. Now, in this situation, plaintiff and defendant number 2 years want that we should be sandwiched whether we are having any amenities or not. So the honorable division bench interpreted the matter. Directed the corporation. So many reports filed,
No.
but why
I-
this has been done by corporation is pending. If that is sorted out, everything will be clear.
I cannot sit
My,
over this issue only
Right.
because the matter is pending before the division bench unless there is order of stay.
Lordship, that is
Right.
correct.
No, you approach the honorable division bench, obtain an order of stay.
So that I can mention.
I am simply,
I cannot. Lordship,
No.
there is a decoder.
these are separate execution proceedings.
Your
My lord, I'll
interest-
show that it is
Mr.
maintainable.
Mr. Bhattacharya, subject to correction. So far my understanding goes, your interest will be prejudiced if the decree is executed,
Lordship.
right? So you have preferred an appeal. The identical issue is before this court.
Lordship.
And I have already asked your friends to
Yes,
justify or to show about the
I'll
maintainability. If
satisfy.
you want this court not to deal with the matter, then there has to have some order from the divisional bench.
My great.
You have to
Great.
move, you have to approach, you express your difficulty. I cannot,
The difficulty would be is this. Then, my lord, on verbal prayer, I have to pray before the division bench that the honorable executing court is proceeding with the matter.
yes, yes,
There
yes,
is no
let him,
delay.
let him say.
So, but I would be unable to show any order of your lordship.
No, no, I am just adjourning the matter.
Dictated, I can place.
I shall adjourn the matter. Yes.
And this part may be recorded since there is no stay, so your lordship is here.
Yes, yes.
Lordship.
Check down.
APOT 78 of 2023.
Just, hold on. Yes, what's your good name?
Shaunak Ghosh, my
Sonak Ghosh.
Ghosh, my lord.
You are the
And I'm the petitioner in the execution application, my lord.
So you are the one of the decree holders.
My lord.
Sonak Ghosh, learned counsel representing. Whom are you representing?
Defendant number 2C, my lord.
2A,
2A, 2B, and 2C, my lord.
2A, 2B, and 2C. Submits that this execution petition has been taken out on behalf of the aforesaid defendants to get delivery of possession of the property allotted to them in the final decree which was passed on compromise.
Right.
It is further submitted that plaintiff, you are the plaintiff, has taken out another application, another identical application, and the same has been disposed of by the coordinate bench.
I will kindly not note identical because the prayers are different.
No, prayers are different, but the decree is same.
Decree is same, my lord.
He has put the decree into execution to get his allotment
From
delivered. You have put the decree into execution to get your allotment
my
delivered.
lord.
Here I join the issue. Why not
Right.
in
That
single
I'll
proceeding?
have to satisfy. I'll have to
Yes.
satisfy, but my lord will kindly not note the word identical, my lord, because that way it seems as if the prayers are identical.
Second one. Another application for execution to get the property delivered, allocated or allotted to him in the final decree delivered. Stop.
This final decree words are also. My lord.
No,
I
no.
clarified this, my lord. This argument.
No. Okay, I will come back. I will come back to you. Stop.
This what will.
The first question that strikes the mind of the court is why multiple execution petition is required to get the final decree executed in a suit for partition. Stop. Mr. Ghosh wants to come back on কবে দেবো বলছি মানডে অসুবিধা হবে আদিত্য বলুন না ফ্রাইডে আমি সব ক্রিমিনাল ম্যাটার গুলোর জন্য ইয়ারমার্ক করছি ফ্রাইডে হলে পরে
So that I can get a breathing time to mention the matter.
Thursday or then you come at 3:30 on Friday. By that time I will.
That is the only issue, my lord.
Gather some courage to flout the resolution. How does it matter? Matter is adjourned to appear on Friday. No, এর মধ্যে Mr. Bhattacharya's submission টা একটু লিখে নেব. He wants to come back. এইটুকু লিখুন.
State of final decree or decree.
According,
yes, that be recorded. What is
Mr. Bhattacharya,
state of final.
You are
Defendant number 1A.
defendant number 1A. Prasun Kumar Bhattacharya. Then
1B. Sorry, I am
1B. Pratik Kumar Bhattacharya. Mr. Pratik Kumar Bhattacharya. Defendant number 1B submits that no final decree has been passed in the proceeding, but a compromise decree has been passed.
part decree that is written in the terms of settlement.
Yes.
It is in the terms of settlement itself, first line, part decree.
Decree drawn up, completed, thereafter part decree.
Anyway,
This is the way they interpret my lord. Each
After
According
drawing
to
up
you-
completion, it's part decree.
please, Mr. Ghosh, this is not the way.
No,
This is not the way.
I will not.
what I submitted, the terms of settlement itself says part decree and subject to compliance of all contingencies, decree will be drawn in respect of each property. So cannot be.
Okay,
final.
okay.
ঠিক আছে, হ্যাঁ, দেওয়া আছে,
কি বললাম ওখানে?
That will influence the proceeding.
In the proceeding, in the terms of settlement, it has been clearly spelled out that the said document will be considered as part decree and
And
subject to
compliance of the contingencies,
subject to certain conditions.
the
Final,
decree will be drawn up.
the decree
Not
will
final.
be, the decree will be drawn up.
Drawn up.
Fine.
That is written.
And we'll kindly record that we are objecting to it.
Yes.
Oh, terms of settlement, terms of the obligation.
However,
No,
Mr.
we are
Ghosh
objecting to their submission, the final decree does not. state.
Mr. Ghosh and Mr. Mukherjee are not in agreement with Mr. Bhattacharya. Yes, stop. Be that as it may.
My lord, the appeal is pending with the court. What I have submitted.
Okay,
APOP
fine.
78 of 2020.
It is further contended that APOT
78 of
78 of 2017
23.
23 since is pending before the Honorable Division Bench.
Fixed on 23 July. Fixed on 23.
Yes, yes. This court may not proceed. This court may not proceed with the application. That is what you are submitting.
Because the municipal commissioner has been directed.
I am not going to record.
Record my submission.
Yes.
No,
Record my
this will go on forever.
And fixed on 23 July.
That's all.
Submission of this, what I made.
Yes.
They will not
Yes.
deny.
Why can't you have some
Because
patience? I fail to understand. They are younger people. I understand. Why can't you? কি হচ্ছে এটা? Honorable Division Bench, there and Honorable Division Bench has passed certain direction upon the municipal commissioner. This court may please not to proceed with the matter. Stop.
And fix the matter on 20.
I do not find any reason to keep the matter pending because of the pendency of an appeal before the Honorable Division Bench. Stop. Let the matter be listed on 21st of July at 3 p.m. I hope this will serve your purpose. You just,
25th July it is indicated so
oh,
that
25th is your
25th
matter.
July is date.
21st kore labh nahi, his matter will appear on 25th. So it
But-
should be anyway, either way, it should be after 25th.
My lord, it is not even connected, my lord.
This
It's not even.
Now it's my prerogative to fix a date.
That
So
I
let
bow
it
down
be
to.
fixed after
Bow
25th.
down to your lordship.
Unless I
28.
Unless I bring this date. That you
No, sir, 28.
No, that is correct. Unless I bring this date,
I'm-
that may be indicated so that I.
No, no.
I am
No.
fixing the matter on 28.
Not.
You are at liberty to approach the Honorable Division Bench,
Yes.
obtain an order of stay and appear before me. Otherwise, I have expressed my mind,
Not. Grateful to you.
3 p.m.
My lord, this order will be uploaded so that on.
Yes,
Monday
it
I
will be
can-
uploaded. It will be uploaded as a matter of course.
Not. Grateful to you.
Deeply.
Thank you. শোনার নেই তো কিছু? এই আস-
That to item number 14. My lord, only one.
Don't be a motorbiker.
No.
You wait. Let my SEO come. Let the list be called on. Then only. Yes, I will rise because I have a division bench matter.
Yes.
দেখি ডাকুন ডাকুন
Pardon me.
কোথায় ছেড়েছিলাম আমরা?
Item number 14, my lord, there is a can application, can 3. Your
No,
lord,
there is nothing.
yes, my lord,
in the
this
list.
can is not listed,
Then
but this can is, my lord, last occasion, your
who is the
lordship,
respondent?
my lord, I have filed the notice of motion and Tolobana, my lord, I don't know who is appearing. And I have served the application for stay, application for substitution, all. Substitution was allowed by the division bench. Stay was also sought. My lord, this can application, your lordship, can 3 is pending.
No. Can 3 is, what is your can 3?
Your lordship kindly, your lordship,
Application for stay.
yes,
You are enjoying interim order of stay.
yes, by the protected by the division bench.
Fine. Have you served this copy of the application to the?
Yes,
Are you appearing?
I am appearing for the respondent in this matter led by my senior Sabyasachi Mukherjee. Lordship, kindly give a direction upon the appellant to serve a copy upon us.
Copy of
Copy of the paper book upon us.
paper book.
I just got this instruction from my senior.
Sabyasachi Mukherjee.
Yes.
Prepared, paper book prepared.
My lord, paper book is prepared. My lord,
Then you collect it from the department. It must be in the department. Your friend is saying it is prepared.
it is informal paper book.
No,
My lord,
whatever.
only one direction, my lord, I am praying for. My lord, let the LCR be called for. That has not been,
Why?
my lord, but the LCR is required.
What is the observation of honorable division bench?
My lord, the
regarding
honorable
LCR?
division bench or, my lord, the honorable division bench, my lord, in the order, it has been
This is a suit for partition, I
put
think.
for part. In the preliminary, against the preliminary degree, I have come, my lord.
Against the preliminary degree, you have come.
Challenging the preliminary.
Very well, let us start hearing as directed by the honorable division bench. If necessary, we will call for the record.
As your lord.
You have the deposition with you.
No, my lord,
Ask your client to obtain certified copy. It will minimize the time.
my lord, let the LCR be called for, because why I am saying so, my lord, the signature and the thumb impression, these two are in, my lord, the difficulty, that is the main crux of the suit.
Have you prayed for scientific examination of those
My
documents?
lord, that application I have applied, that application
Before the
was
landed
not considered by the trial court as even the appeal court.
Fine. So that is there in the record. You will argue.
That is the, my lord, then
You served. You have been served with copy of stay application.
No, sir.
No.
I have no instruction.
I have,
Served the copy of the application.
my lord, this is the copy of the, I have to check if.
You check it up, submit affidavit of service.
My
And
affidavit of service is there. My lord, it was.
When did you file?
Kindly, your lordship.
When did you file? When did you file?
My lord,
Yes,
earlier occasion.
earlier occasion. And
My lord, I have a copy of the affidavit of service.
you are Mr. Chatterjee.
Yes, my lord, on 4th April 2023, my lord, I have affirmed the affidavit of service.
Yes, it's on
Yes.
record.
I have already served all the copies.
What is your good name?
Sir,
What is your good name?
my name is Mukesh Khanna. Mukesh Khanna.
Mukesh Khanna.
Yes, sir.
Mr. Mukesh Khanna
Order gulo rakhe na.
is representing the respondents. You are representing all the respondents. Mr. Chatterjee, learned counsel for the appellant.
I'm late.
Is
Like,
requested to
yes, sir.
give copy of the application being 3 of 23. Are you going to give it in court itself?
my lord,
to your friend.
if your lordship so
No, no.
desire, my lord,
If you give it, I will record it that yes, it has been
yes.
given.
I will give the copy.
Okay, তাহলে ওটাকে একটু ঘুরিয়ে লিখে দিন। Mr. Chatterjee, learned counsel for the appellant.
My lord, subject to his file is Bhokalatnama, otherwise I will be in difficulty.
I will file in the course of the day, not sure. This give me
My lord,
some-
trivial-
this is only instruction.
Bhokalatnama as yet, my lord.
This is only instruction what I got from my senior lordship.
পুরোটা কাটুন, কেটে বলুন, Mr. Chatterjee, learned counsel for the appellant is present. Mr. Mukesh Khanna, learned counsel, submits that he is representing the respondents and he undertakes to file Wakalatnama in the department in course of the day. Stop. It is further submitted that the respondents have not been served with the copy of the application for stay. Mr. Chatterjee makes over the copy of Can 3 of 23 to Mr. Khanna. I am recording that you are making over the
Copy of
copy.
the Can 3.
Can 3.
My lord, the Can 3, my lord, I have to make a copy and I
Okay.
today itself. If
Mr. Chatterjee undertakes to make over a copy of the application in course of the day. Matter, let the matter be listed. And what about the paper books?
my lord, paper book is prepared. My lord, paper book is prepared.
Prepared. So exchange the paper books.
Lordship, paper book has not been yet received, my lord. We did
I
not.
have also not received it.
Lordship.
It is in the pipeline, just
My
wait.
lord, may I file the paper book in the department
In the
so that everybody can
Yes, you file the
paper
file
book
it.
in the department.
It is further submitted by Mr. Chatterjee that pursuant to the direction, paper books are prepared. Liberty is given to the appellant to deposit the paper books in the department. You collect it from the department.
Great.
Now what is left? Matter may be
My lord,
fixed for
as
only
you-
your interim stay.
my lord, interim stay may be extended for a period of,
But when we will hear the appeal?
my lord, appeal, my lord, may I suggest one thing?
Yes.
My lord, let the LCR be called for. My lord, let the LCR be called for.
It
Because the
will not
genuineness-
help you, Mr. Chatterjee. I will call for the LCR with the direction upon the learned trial court to prepare a skeleton record so that commission work doesn't suffer.
My lord, yes, my lord.
If
in
you are
this-
agreeable
my
to
lord,
this, just tell me.
Yes, your lordship, everything is, my lord. All right, my lord, I will just.
Work of commission will go on.
Yes,
Final decree shall not be drawn up.
yes, yes. That will suffice. my
That is
purpose.
the usual course.
Yes.
You have challenged the preliminary decree. Why
Yes.
final decree be drawn up?
And that is the usual order, your lordship.
Yes.
knows better than me.
No, I don't know anything better than you. But you tell me what to do. We don't require LCR. You have the copy of deposition.
Lordship. No, my lord, actually, I don't have any instruction regarding that.
You advise your client
Okay,
to equip you with the copy of deposition, if necessary, so that if necessary, we can look into it.
My lord, your lordship, perhaps this is the order of the Honorable Justice Biswajit Basu in respect of other matter in preliminary decree. My lord, this is also same self order, your lord, his lordship was passed that the final decree
Look,
will
you
not be
have
passed.
challenged the preliminary decree. Pending that appeal, how could final decree be passed?
That,
But there is no point wasting time. Let the commission work go on.
yes,
It is
everything.
subject to the result of this
Yes,
appeal.
Yes. Final decree
Should
will not.
I pass that order? Can 3 will be disposed of in that manner, or
No,
you want to
no,
file
my lord.
opposition?
I want to file opposition, but kindly give me 1 week accommodation, your lordship.
Very well.
Very good.
You are Mr.
I'm led by learned advocate Mr. Sabyasachi Mukherjee. I am Vivek De.
Sabyasachi Mukherjee. You are
I am Vivek De.
Vivek.
Yeah.
Vivek means conscience. Whose conscience? Vivek, do you
De.
have any surname? They.
De.
Mr. Khanna is dislodged.
Oh, আচ্ছা তো এখানে।
লিখে দিন. Learned counsel for the respondent is seeking an accommodation for a week. Let the matter be listed on 27th of July.
Grateful enough.
The 27th of July, the interim order shall annul till the interim order of stay shall annul till that day.
Grateful.
My lord, copy of the stay application I have already handed.
Fine.
Kindly record.
In open court.
Affidavit file করবে। Very
If you want to file opposition, file it and come back on 27th.
আমি তলাকোটা ইয়েতে ডিপার্টমেন্টে থাকি।
ডাকুন।
I am for the opposite party, my lord.
Yes.
I'll be seeking for a month's
16.
time, my lord. Because, my lord, I need
Who is
some
the
time.
appellant? You were the appellant. Second miscellaneous appeal.
Second miscellaneous appeal. What happened, my lord? Our suit decreed 93.
What
Thereafter,
was your suit for?
suit for declaration permanent injunction.
Fine.
Decreed 93, my lord. Then they have filed a order 9 rule 13 for setting at a that got dismissed. They filed a order 9 rule 9 for restoration that got dismissed. Now with a section 5, they have restored the order 9 rule 9 and now trying to, my lord, restore the order 13 rule 13 which is done 20 years back. My lord, what happens, my lord? I need certified copy of this document. My lord, kindly seize my lord's last order. My lord has directed me for written my lord, my affidavits in opposition, my lord. My lord, I need those documents, my lord, of order 9 rule 9 and other their depositions.
Your friend has done the job for you. He has annexed everything.
No, he has perhaps not annexed everything, my lord.
Not everything.
Not everything, my lord. There are far more, my lord. All the records, my lord, how they have proceeded in the matter, my lord, that has to be shown before, my lord.
Like,
My lord, I have only one objection.
yes.
My lord, on Monday, that is 17th, the matter is fixed before SDLR. They are in Badwan Sador, my lord. Now,
Regarding recording, etc.
yes, my lord. Now, what is happening? The SDLR is having a very aggressive and bad temper.
No, this
now,
is subject to.
No, my lord, Now, as they are taking time, my lord, I have no objection on the because my learned friend is taking, I have no objection. Now, he had said that he will pass the order. That is
My
the
lord, my lord.
My lord, I have no
what
other
they-
prayer, my lord.
What they have filed
kindly
is
say
a
me that,
appeal. It's a appeal. My lord,
whatever
the
be the issue, my lord.
SDLR is not a party over here, my
I know that, my lord.
my lord, they are asking
Now,
for.
now, my lord, then he have to give he should have given the opposition in time, my lord. Now he's objecting to that point. I'm not asking to. My only prayer is that, my lord, that he had strictly said that we'll pass the order.
Whatever decision is taken by SDLRO is subject to the result of this appeal.
Well, then they will change the name definitely, my lord. If
I need only that protection, my lord, so that
No,
otherwise, my lord,
That-
my lord,
that
my lord,
is
only
natural
one, my lord,
protection, my lord.
Another thing, my lord. If their advocate appears over there, my lord, the defendant advocates appear over there. If they say that yes, they have taken time, otherwise, because if I prefer time over there,
my lord, how
whatever
that
the issue,
guarantee
they
can
will
be
pass the
given
order,
by
my
me?
lord. That is the only protection.
how can I control everything
I
by
know,
a
my lord,
remote?
that is the only protection, my lord. That is the problem.
It's a natural corollary. If you succeed, whatever record is done by
And
the
let him
SDLRO,
succeed,
it
my
will
lord.
go.
He may change the record, my lord. My lord, that
I
is the
may change the record.
SDLR.
SDLR record.
May change the record, my lord. Then thereafter everything, my lord.
My lord,
Because
if I change
difficulty.
the
Please
SDLR,
appreciate. The difficulty is SDLRO is not before the court.
No, my lord.
How can I pass any direction upon him?
this is
I
not
can
even.
You have to appreciate that.
Prayer, I shouldn't wait before that.
But-
But the fact is, this is the fact.
But the law says if you succeed in this appeal, the decree will follow. Record will reflect the result of the suit.
But if anyway it changes, my lord, then it will be a great manner. If any some protection, my lord. But
Is there any application for the injunction? No.
no, my lord.
Nothing, my lord.
Then how can I pass any order and where?
My lord, what I
You
can
do one thing, instruct them not to proceed with it.
I'll
That's enough for
definitely,
me. That's enough for me.
I'll
I'm grateful.
definitely instruct them.
Just wait for some more days. Yes. You are Mr. Dev. Are you Mr. Dev? Yes. Heard Mr. Basu and Mr. Dev, learned counsel representing the parties. Mr. Dev is seeking an accommodation for 4 weeks to prepare affidavit in opposition Mr. Basu, however, expresses his concern.
My lord, I am Onuran Samanto. I am.
Oh, you are Mr. Onuran Samanto.
I am Mr. Deputy Vasu, my lord.
Okay. Mr. Samanto, however, expresses his anxiety that a proceeding has been taken out before the SDLRO. SDLRO. BL and LRO, SDLRO. SDLRO, Bardhaman.
But Purva Bardhaman.
Purva Bardhaman. Pursuant to the decree passed in favor of the respondents.
Will I say the appeal case number was there? No. If you let's allow them.
In a, no,
All right.
he is assuring you he will advise the client not to.
That also that cannot be recorded because I don't know what, because that part cannot be recorded before lordship, but their typical situation goes on over there, my lord, before ATL.
My lord knows the lower court lawyers, my lord. My lord knows the lower court lawyers. They are very cantankerous, my lord. I'll definitely have a word, my lord, tonight.
Not all of them, please. Don't generalize.
My lord, I'm not generalizing, my lord, but
there are great lawyers. They are great lawyers also.
My lord, but they have to do a gallery, my lord, because their clients are always sitting at the back.
Yes. Mr. Dev, however, submits that he will instruct his clients not to proceed with the matter before the SDLO. So, let the matter be listed on 8th of August under the heading hearing with liberty to file affidavit in opposition. I don't think you need to file any reply to that. If necessary, in the meantime, you just file it. But on the parties are directed to exchange their pleadings in the meantime. Exchange their pleadings in the meantime. Hello.
My lord.
My lord, item number 15, my lord, it was not called, my lord. Item number 15,
My lord, item number 15 has been dismissed.
Dismissed, my lord.
Yes, that is why it is not called.
My lord, instead of 8, my lord, can it be 9 or
9? Okay, fix it on 9.
My lord, my instruction is 2 weeks, my lord. My lords had kept it this Monday, my lord. I asked the learned court officer, my lord. He said the matter is kept on Monday. Item 15, my lord.
Not matter. Not today.
My lord, it should be for 2 weeks, my lord. I pray for adjournment for 2 weeks, my lord. Monday is the Shraddh ceremony, my lord.
Mr. Chatterjee is appearing in this matter.
Yes, my lord. For the
Mr.
respondent.
Banerjee is appearing for the appellant.
Yes, my lord.
He will come on Monday. He will make his submission. It will be adjourned on that day.
Monday, my lord.
Monday. You come on Monday. Otherwise,
my lord, 7th August, my lord. What my diary shows is, my lord.
Where is your friend? Yes, 7th of August.
My lord, Monday difficulty, my lord.
Monday, I shall fix the date for hearing of the appeal.
It is a
So
Shraddh-
don't worry.
My lord.
19 both sides are here.
Well, item 19 is a very short matter. Yesterday, I argued that matter. Condonation of delay, my lord. That matter, substitution matter, my lord, section 5. But 448 days delay.
Item number 16. Have patience. If time permits, I will take up your matter. Otherwise not. 17. Jakun. 9.
My lord, your lordship, I was just in the midst of my submission yesterday, my lord. That the affidavit, your lordship says, where is the affidavit original? My lord, I have got that. My lord, here, my lord, your lordship may recall, my lord, there is delay of 448 days. My lord, the only, my lord, the excuse sought to be taken is that because of the
Affidavit.
reply has also been filed.
36 হয়েছে না আমার ওখানে কটায় আছে
I will take only 5 minutes.
কত হয়েছে no not today নিন into affidavit in opposition filed on behalf of the respondent number 1A and 1B is taken on record. You have filed a reply as well,
Yes, yes, my lord,
Okay.
yes.
together with, madam, together with record together with affidavit in reply. Let the matter be listed on Monday under the heading for orders. Yes. RK, 20th.
I'm the appellant.
Hmm.
LCR has not come. Paper book we have filed. The lower court record has not yet come. Kindly
Is necessary?
necessary.
Why?
LCR required because the point involved is that my lord, the suit is bad. We have taken the point. The suit is bad because they have not asked for recovery of possession. In the evidence also they have admitted our possession. In the plain.
Don't you have
to show that.
deposition? Don't you have
That's what your
deposition?
lordship on the last day pointed out, my lord, your lordship asked for the certificate copy, you don't have that. That is why your lordship.
We have possession, that's why, my lord, we have.
Do you have the copy of deposition with you? I am not concerned with possession. Do you have? Give me 2 copies, 2 sets.
2 sets, my lord, I have to, my lord, Xerox set, my lord.
Then you get it Xerox, give 1 copy to Mr. Banerjee and bring 1 for the court.
My lord, can you take up online?
90.
My lord,
I took for it.
একটু পরে কবে? You
Next monthly
suggest-
list. They will come in the next monthly list, my lord. So second appeal, my lord, after admission.
No, my lord, this is, my lord, 2 of 1971, my lord. You know, 1991, this is it.
Kindly extend
Mr.
the
Mr. Basu will argue or Mr. Basu will lead you.
Client has briefed me for arguing, my lord. I'll argue if client briefs him, he will come.
Okay.
No, no.
He is, you are the appellant.
We are the
Mr. Basu is the leader.
Record, my lord. If the record comes,
No.
lordship directs, my lord, if your lordship directs, gives a time frame, the record will come within that. We have deposited the special messenger cost also.
Only
No,
point is
this
to
is one of the points. my lord.
see the testimony of the witness where he has admitted. That is what you
Testimony-
want to show.
testimony, pleading is before your lordship, but not, I wanted not the record to be here.
Only the admission part. He will provide you the copy.
Because on the last day we crossed this hurdle. We convinced your lordship the record should come and we deposited them at special messenger cost. So again, I have to cross the same hurdle today. my lord. So kindly, my lord, makes it a time bound process, my lord, the record will come.
এটা কি এতগুলো কি রিপোর্ট দিয়েছি? It is most humbly submitted that it Learned Council expense service of the notice of appeal dispensed with in terms of the honorable court's order number 8 for paper book appear.
Paper
Now,
filed on 28th
no,
of.
I have called for the LCR, but in reply to your letter that is so and so, the has already been sent to learned civil judge junior division first. What's going on? Yes, peruse the office report. Point number III. And the letter of learned additional sessions judge first track court Chandan Nagar Hubli dated 22nd June 2023. Stop. The response is far from being satisfactory. Learned lower appellate court is directed to take initiative so that the lower court records reach this court by 31st of July. Let the matter be listed on 2nd of August.
Interim order is still 3rd of August.
So fine, you are protected.
Can it be extended for 7 more days? If,
No,
if for some reason it is not taken up. I
I
don't know
will,
why. it's-
I will take care of that situation on that day,
Second.
subject to supply of. Now you have to excuse me, I have division bench matter now, I have to rush.
Much obliged.
Sorry. Thank you.